currently being assaulted and battered in the brain. I'm going to get on my tablet because it's going to happen anyway. I want to read this so that I keep this. John Keating's Cracking the Code, number 7. The courts are operating under statute law. A statute is defined in Black's 4th edition revised as a kind of bond or obligation of record, being an abbreviation for statute merchant or statute staple. Statute merchant is defined as a security for a debt acknowledged to be due, entered into before the chief magistrate of some trading town, pursuant to the statute 13 Edward 1, de mercatoribus, by which not only the body of the debtor might be imprisoned and his goods seized in satisfaction of the debt, but also his lands might be delivered to the creditor, till out of the rents and profits of them the debt be satisfied. This is also called a pocket judgment. Statute staple is a 1353 statute establishing procedure for settling disputes among merchants who traded in staple towns. The statute helped merchants receive swift judgment for debt. Cf. Statute merchant. 2. A bond for commercial debt. A statute staple gave the lender a possessory right in the land of a debtor who failed to repay a loan. See staple. Quote, a popular form of security after 1285 was the statute staple, whereby the borrower could, by means of a registered contract, charge his land and goods without giving up possession. If he failed to pay, the lender became a tenant of the land until satisfied. The borrower under a statute or reconnaissance remained in possession of his land, and it later became a common practice under the common law forms of mortgage, likewise to allow mortgagor to remain in possession as a tenant at will or at sufferance of the mortgage. That's from J.H. Baker, An Introduction to English Legal History, 354, 3rd edition, 1990. Recognizance is a bond or obligation of record binding a person to some act as to appear in court and subject to forfeit money if obligation is not fulfilled. FIFA is short for Latin phrase fieri faciamus, let it be made, was a court execution to the sheriff to levy take the property of a debtor in order to satisfy a judgment. See judgment and execution dockets above. The sheriff might typically keep track of FIFAs in a sheriff's FIFA docket book. Usually written on a fill-in-the-blank form, a FIFA names the parties to the court judgment and the value of property to be taken to satisfy the judgment. On the back, the sheriff or his deputies annotate their actions in carrying out the order. The FIFAs were to be returned to the court which issued them, and the actions annotated on the judgment docket. Theoretically, the docket books should contain everything that was noted on the FIFAs. In Webster's 1913 dictionary, the word stand is defined as being also the word statute. I believe this is why the judge in every court always asks, do you understand? Stand the charges being assessed against you. In the OE, or Old English, it is understandin'. To stand under or to be subjected to or under the control of, or I am subjecting or agreeing to put myself under the control of, or putting myself under the statute or bond of record. I have been doing more research on our prison system via the internet and have found out some interesting things regarding what is really going on in the courtroom. The court is looking for an acceptance and acceptor under 3-410 of the UCC, as the principal has the primary obligation to pay or discharge any instrument presented for acceptance, since they are presenting a bill of exchange, an indictment, for acceptance. This is called an acceptance for honor, which involves a negotiable instrument, especially a bill of exchange, an indictment, that has been accepted for payment. The complaint information or indictment is a third-party draft, commercial paper, or bill of exchange under Article 3 of the UCC. The grand jury foreman is the drawer or maker of the indictment by his signature. The defendant/debtor or straw man is the drawee, and the state is the payee, and the live man is the payor. What they are doing in the courtroom is all commercial. This is in conformity to 27 CFR 72.11, where it says all crimes are commercial. What the judge and prosecutor are doing in the courtroom is making a commercial presentment under Section 3-501. 1. Quote, unless excused, Section 3-511, presentment is necessary to charge secondary parties as follows, end of quote. A. Presentment for acceptance is necessary to charge the drawer and endorsers of a draft where the draft so provides, or is payable elsewhere than at the residence or place of business of the drawee, or its date of payment depends upon such presentment. The holder may, at his option, present for acceptance any other draft payable at a stated date. B. Presentment for payment is necessary to charge any endorser. C. In the case of any drawer, the acceptor of a draft payable at a bank or the maker of a note payable at a bank, presentment for payment is necessary, but failure to make presentment discharges such drawer, acceptor, or maker only as stated in Section 3-502(1) capital B. If you don't accept the charge or presentment, you are in dishonor for non-acceptance under 3-505 of the UCC, small c, and 3-501(2), small a, small b. Acceptance is the drawer's signed endorsement or signed engagement to honor the draft as presented. It must be written on the draft and may consist of his signature alone. It becomes operative when completed by delivery or notification, 3-410 of the UCC. You, meaning me, are the fiduciary trustee of the straw man, which is a Sestake trust. In this capacity, you have the responsibility to discharge all his debts by operation of law. Quote, all monies of the Federal Reserve Board shall be treated as trust funds for the purpose of Section 906, small a, 2, footnote 1 of Title 2. This section is effective for fiscal year 1986 and every fiscal year thereafter. Title 12 Banks and Banking, Chapter 14, Section 1772, small e. Every account is a trust. This is why every deed, conveyance, or transfer uses the words grantor, grantee, or assigner, assignee, or transferor, or transferee. You are also the principal or asset holder on the private side of the accounting ledger. You are holding the exemption necessary to discharge the debt. When they monetize debt, they have a principal. Capital and interest is what circulates as principal and is called revenue or revenue. Principal is where venue lies. Revenue is a tax debt or tax bills. All bills, when presented, represent revenue, interest, capital, or accruals circulating from you as the principal. When it is returned back to you as capital or interest, it is called income or incoming. This method of accounting is called the accrual accounting method and is represented by debits and credits. Debits are assets, credits are liabilities. The credits and liabilities have to be in balance. This is accomplished through double bookkeeping entries or reverse bookkeeping entry. These bookkeeping entries are the funds referred to in commercial banking. When you are in dishonor, they cannot use your exemption to pass the debt or charge through your account to obtain a discharge. So they sell your dishonor, which has a commercial of $1 million for each count. When Social Security number is assigned or issued, a blank bond is issued, and when you are imprisoned, the bond is filled out. This bond is called a bid bond, Standard Form 24. Rev.10/98, prescribed by GSA/FAR 48 CFR 53.228 small a. This is also called a prison bond. These are also referred to as contract surety bonds. The first, the bid bond, provides financial assurance that the bid has been submitted in good faith and that the contractor intends to enter into the contract as the price bid and provide the required performance and payment bonds. The second, the performance bond, protects the obligee from financial loss should the contractor fail to perform the contract in accordance with the terms and conditions of the contract documents. The third kind of contract bond is the payment bond, which guarantees that the contractor will pay certain subcontractor, labor, and material bills associated with the project. The fourth bond, and most important, is the Standard Form 28, prescribed by GSA/FAR 48 CFR 53.228 small e, OMB number 9000-0001. If you read this form carefully, it says under the sworn statement, I also depose and say that concerning any stocks or bonds included in the assets listed below, that there are no restrictions on the resale of these securities pursuant to the registration provisions of Section 5 of the Securities Exchange Act of 1933. The word securities takes you back to Section 8-102(9) of Article 8 of the UCC, which defines securities as a financial asset. Small I, security, II, obligation of a person or a share, participation of a person or in property or an enterprise of a person, which is or is of a type, dealt in or traded on financial markets, or which is recognized in any area in which it is issued or dealt in as a medium for investment, or, this is triple small I, any property held by a securities intermediary for another person in a securities account if the securities intermediary has expressly agreed with the other person that the property is to be treated as a financial asset under this article. As the context requires, the term means either the interest itself or the means by which a person's claim to it is evidenced, including a certificated or uncertificated security, a security certificate, or a security entitlement. The definition of security has three components. First, there is the subparagraph, small I, test that the interest or obligation be fully transferable in the sense that the issuer either maintains transfer books or the obligation or interest is represented by a certificate in bearer or registered form. Second, there is the subparagraph, two small i's, test that the interest or obligation be divisible, that is, one of a class or series as distinguished from individual obligations of the sort governed by ordinary contract law or Article 3. Third, there is the subparagraph III, all in lowercase, functional test, which generally turns on whether the interest or obligation is or is of a type, dealt in or traded on securities markets or securities exchanges. There is, however, an opt-in provision in subparagraph 3 small i's, which permits the issuer of any interest or obligation that is a medium of investment, to specify that in a security governed by Article 8. Take a drink of coffee. The divisibility test of subparagraph II applies to the security that is the underlying intangible interest, not the means by which that interest is evidenced. Thus, securities issued in book entry only form meet the divisibility test because the underlying intangible interest is divisible via the mechanism of the indirect holding system. This is so even though the clearing corporation is the only eligible direct holder of the security. The third component, the functional test in subparagraph III, lowercase, provides flexibility when ensuring that the Article 8 rules do not apply to interest or obligations in circumstances so unconnected with the securities markets that parties are unlikely to have thought of the possibility that Article 8 might apply. Subparagraph 3 small i's, capital A, covers interests or obligations that either are dealt in or traded on securities exchanges or securities markets, or are of a type dealt in or traded on securities exchanges or securities markets. The is dealt in or traded on phrase eliminates problems in the characterization of new forms of securities, which are to be traded in the markets, even though no similar type has previously been dealt in or traded in the markets. Subparagraph III, capital B, covers the broader category of media for investment, but it applies only if the terms of the interest or obligation specify that it is an Article 8 security. This opt-in provision allows for deliberate expansion of the scope of Section 8. Section 8-103 contains additional rules on the treatment of particular interests as securities or financial assets. 1. Part 5 rules apply to security entitlements, and Section 8-501 small b provides that a person has a security entitlement when a financial asset has been credited to a security account. Thus, the term securities account specifies the type of arrangements between institutions and their customers that are covered by Part 5. A securities account is a consensual agreement in which the intermediary undertakes to treat the customer as entitled to exercise the rights that comprise the financial asset. The consensual aspect is covered by the requirement that the account be established pursuant to agreement. The term agreement is used in the broad sense defined in Section 1-2013. There is no requirement that a formal or written agreement. 1-2013, agreement, as distinguished from contract, means the bargain of the parties in fact as found in their language or inferred from other circumstances, including course of performance, course of dealing, or usage of trade as provided in Section 1-303. 1-303, course of performance, course of dealing, and usage of trade. Small a. A course of performance is a sequence of conduct between the parties to a particular transaction that exists if 1. The agreement of the parties with respect to the transaction involves repeated occasions for performance by a party, and 2. The other party, with knowledge of the nature of the performance and opportunity for objection to it, accepts the performance or acquiesces in it without objection. B. A course of dealing is a sequence of conduct concerning previous transactions between the parties to a particular transaction that is fairly to be regarded as establishing a common basis of understanding for interpreting their expressions and other conduct. C. A usage of trade is any practice or method of dealing having such regularity of observance in a place, vocation, or trade as to justify an expectation that it will be observed with respect to the transaction in question. The existence and scope of such a usage must be proved as facts. If it is established that such a usage is embodied in a trade code or similar record, the interpretation of the record is a question of law. D. A course of performance or course of dealing between the parties or usage of trade in the vocation or trade in which they are engaged or of which they are or should be aware is relevant in ascertaining the meaning of the parties' agreement, may give particular meaning to specific terms of the agreement, and may supplement or qualify the terms of the agreement. A usage of trade applicable in the place in which part of the performance under the agreement is to occur may be so utilized as to that part of the performance. E. Except as otherwise provided in subsection F, the express terms of an agreement and any applicable course of performance, course of dealing, or usage of trade must be construed whenever reasonable as consistent with each other. If such a construction is unrecognizable, 1. Express terms prevail over course of performance, course of dealing, and usage of trade. 2. Course of performance prevails over course of dealing and usage of trade. And 3. Course of dealing prevails over usage of trade. F. Subject to Section 2-209 and Section 2A-208, a course of performance is relevant to show a waiver or modification of any term inconsistent with a course of performance. G. Evidence of relevant usage of trade offered by one party is not admissible unless the party has given the other party notice that the court finds sufficient to prevent unfair surprise to the other party. Code of Federal Regulations, Title 48, Volume 1, revised as of October 1st, 2003, from the U.S. Government Printing Office via GPO access, Site 48 CFR 28.203-5, page 541 to 542. Title 48, Federal Acquisition Regulation System, Chapter 1, Federal Acquisition Regulation, Part 28, Bonds and Insurance, Table of Contents, Subpart 28.2, Sureties and Other Security for Bonds, Section 28.203-5, Release of Lien. Small a. After consultation with legal counsel, the contracting officer shall release the security interest on the individual's surety's assets using the optional Form 90. Release of lien on real property or optional Form 91, release of personal property from escrow, or a similar release as soon as possible, consistent with the conditions in subparagraphs small a, 1, and 2 of this subsection. A surety's assets pledged in support of a payment bond may be released to a subcontractor or supplier upon government receipt of a federal district court. Page 542. Judgment or a sworn statement by the subcontractor or supplier that the claim is correct, along with a notarized authorization of the release by the surety stating that it approves of such release. 1. Contracts subject to the Miller Act. The security interest shall be maintained for the later of, lowercase I, 1 year following final payment, 2 small i's, until completion of any warranty period applicable only to performance bonds, or 3 small i's, pending resolution of all claims filed against the payment bond during the 1 year period following final payment. 2. Contracts subject to alternative payment protection, 28.102-1 The security interest shall be maintained for the full contract performance period plus 1 year. 3. Other contracts not subject to the Miller Act, the security interest shall be maintained for 90 days following final payment or until completion of any warranty period. Applicable only to performance bonds, whichever is later. B. Upon written request, the contracting officer may release the security interest on the individual surety's assets in support of a bid guarantee based upon evidence that the offer supported by the individual surety will not result in contract award. C. Upon written request by the individual surety, the contracting officer may release a portion of the security interest on the individual surety's assets based upon substantial performance of the contractor's obligations under its performance bond. Release of the security interest in support of a payment bond must comply with the subparagraph a 1 through 3 of this subsection. In making this determination, the contracting officer will give consideration as to whether the unreleased portion of the lien is sufficient to cover the remaining contract obligations, including payments to subcontractors and other potential liabilities. The individual surety shall, as a condition of the partial release, furnish an affidavit agreeing that the release of such assets does not relieve the individual surety of its obligations under the bond or bonds. 57 FR 48988, November 28, 1989, as amended at 61 FR 31652, June 20th, 1996. Code of Federal Regulations, Title 48, Volume 1, revised as of October 1st, 2004, from the U.S. Government Printing Office via GPO access, Site 48 CFR 28.208-3, page 553 to 554. Title 48, Federal Acquisition Regulation System. This book contains Chapter 1, Parts 1 to 51. Chapter 1, Federal Acquisition Regulation. Part 28, Bonds and Insurance, Tables of Contents. Subpart 28.2, Sureties and Other Security for Bonds. Section 28.204-3, Irrevocable Letter of Credit, ILC. Lowercase a. Any person required to furnish a bond has the option to furnish a bond secured by an ILC in an amount equal to the penal sum required to be secured. See 28.204. A separate ILC is required for each bond. Lowercase b. The ILC shall be irrevocable. Require presentation of no document other than a written demand and the ILC and letter of confirmation, if any, expire only as provided in paragraph f of this subsection and be issued/confirmed by an acceptable federally insured subsection. By an acceptable federally insured financial institution as provided in paragraph g of this subsection. c. To draw on the ILC, the contracting officer shall use the site draft set forth in the clause at 52.228-14 and present it with the ILC, including letter of confirmation, if any, to the issuing financial institution or the, this is from page 554, confirming financial institution, if any. d. If the contractor does not furnish any acceptable replacement ILC or other acceptable substitute at least 30 days before an ILC's scheduled expiration, the contracting officer shall immediately draw on the ILC. small e. If after the period of performance of a contract where ILCs are used to support payment bonds, there are outstanding claims against the payment bond, the contracting officer shall draw on the ILC prior to the expiration date of the ILC to cover these claims. Small f. The period for which financial security is required shall be as follows. 1. If used as a bid guarantee, the ILC should expire no earlier than 60 days after the close of the bid acceptance period. 2. If used as an alternative to corporate or individual sureties as security for a performance or payment bond, the offeror/contractor may submit an ILC with an initial expiration date estimated to cover the entire period for which financial security is required, or an ILC with an initial expiration date that is a minimum period of 1 year from the date of issuance. The ILC shall provide that unless the issuer provides the beneficiary written notice of non-renewal at least 60 days in advance of the current expiration date, the ILC is automatically extended without amendment for 1 year from the expiration date or any future expiration date until the period of required coverage is completed and the contracting officer provides the financial institution with a written statement waiving the right to payment. The period of required coverage shall be small I for contracts subject to the Miller Act, the later of. Uppercase A, 1 year following the expected date of final payment. Capital B, for performance bonds only until completion of any warranty period, or uppercase C, for payment bonds only until resolution of all claims filed against the payment bond during the 1 year period following final payment. 2 lowercase i's. For contracts not subject to the Miller Act, the later of capital A, 90 days following final payment, or capital B, for performance bonds only until completion of any warranty period. Lowercase g. Only federally insured financial institutions rated investment grade or higher shall issue or confirm the ILC. Unless the financial institution issuing the ILC had letter of credit business of at least $25 million in the past year. ILCs over $5 million must be confirmed by another acceptable financial institution that had letter of credit business of at least $25 million in the past year. 1. The offeror contractor shall provide the contracting officer a credit rating from a recognized commercial rating service as specified in Office of Federal Procurement Policy Pamphlet Number 7, C 28.204-3, lowercase h. That indicates the financial institution has the required rating or ratings as of the date of issuance of the ILC. 2. If the contracting officer learns that a financial institution's rating has dropped below the required level, the contracting officer shall give the contractor 30 days to substitute an acceptable ILC or shall draw on the ILC using the site draft in paragraph small g of the clause at 52.228-14. Lowercase h. 1. Additional information on credit rating services and investment grade ratings is contained within Office of Federal Procurement Policy Pamphlet Number 7, Use of Irrevocable Letters of Credit. This pamphlet may be obtained by calling the Office of Management Budget's Publication Office at 202-395-7332. 2. A copy of the Uniform Customs and Practice, UCP, for documentary credits, 1993 revision, International Chamber of Commerce publication number 500 is available from ICC Publishing, Inc., 156 Fifth Avenue, New York, New York, zip code 10010. Okay. 61 FR 31653, June 20th, 1996, as amended at 62 FR 44807, August 22nd, 1997. 52.228-14, irrevocable letter of credit. As prescribed in 28.204-4, insert the following clause. Irrevocable letter of credit, December 1999. A. Irrevocable letter of credit, ILC, as used in this clause, means a written commitment by a federally insured financial institution to pay all or part of a stated amount of money until the expiration date of the letter. Upon presentation by the government, the beneficiary, of a written demand thereof, therefore, neither the financial institution nor the offerer contractor can revoke or condition the letter of credit. B. If the offerer intends to use an ILC in lieu of a bid bond, or to secure other types of bonds such as performance and payment bonds, the letter of credit and letter of confirmation formats in paragraph small e and small f of this clause shall be used. Lowercase c. The letter of credit shall be irrevocable, shall require presentation of no document other than a written demand, and the ILC, including confirmation letter, if any, shall be issued confirmed by an acceptable federally insured financial institution as provided in paragraph small d of this clause. And 1. If used as a bid guarantee, the ILC shall expire no earlier than 60 days after the close of the bid acceptance period. 2. If used as an alternative to corporate or individual sureties as security for a performance or payment bond, the offerer or contractor may submit an ILC with an initial expiration date estimated to cover the entire period for which financial security is required, or may submit an ILC with an initial expiration date that is in a minimum period of 1 year from the date of issuance. The ILC shall provide that unless the issuer provides the beneficiary written notice of non-renewal at least 60 days in advance of the current expiration date, the ILC is automatically extended without amendment for 1 year from the expiration date or any future expiration date until the period of required coverage is completed and the contracting officer provides the financial institution with a written statement waiving the right to payment. The period of required coverage shall be lowercase I. For contract subject to the Miller Act, the later of, uppercase A, 1 year following the expected date of final payment, uppercase B, for performance bonds only until completion of any warranty period, or uppercase C, for payment bonds only until resolution of all claims filed against the payment bond during the 1 year period following final payment. Lowercase ii, for contracts not subject to the Miller Act, the later of, uppercase A, 90 days following final payment, or uppercase B, for performance bonds only until completion of any warranty period. Lowercase d. Only federally insured financial institutions rated investment grade or higher shall issue or confirm the ILC. The offerer contractor shall provide the contracting officer a credit rating that indicates the financial institution has the required rating or ratings as of the date of issuance of the ILC, unless the financial institution issuing the ILC had letter of credit business of at least $25 million in the past year. ILCs over $5 million must be confirmed by another acceptable financial institution that had letter of credit business of at least $25 million in the past year. Lowercase e. The following format shall be used by the issuing financial institution to create an ILC. And they are showing it to us, so let me show it to you on this. That's what it should look like. You can pause that. Oh, there's more of it here. Let me do this. And you can pause it on it. That goes to number 5. And then here's the rest of it. Well, no, I'm going to have to do more. Here's more of it. Oh, my finger's in the way. Wow, this is a really long document. This is the little bit, the bottom part of it. So let me take a look at what it's, everything in that document. So it asks for issue date, irrevocable letter of credit number, account party's name, account party's address, for solicitation number, 2, U.S. government agency, U.S. government agency's address. 1, we hereby establish this irrevocable and transferable letter of credit in your favor for one or more drawings up to United States in the dollar amount. This letter of credit is payable at the issuing financial institution and, if any, confirming financial institution's office at and the issuing financial institution's address, if any, confirming financial institution's address, and expires with our close of business on the date or any automatically extended expiration date. 2, we hereby undertake to honor your or the transferee's cite drafts drawn on the issuing or, if any, the confirming financial institution for all or any part of this credit if presented with this letter of credit and confirmation, if any, at the office specified in paragraph 1 of this letter of credit on or before the expiration date or any automatically extended expiration date. 3, this paragraph is omitted if used as a bid guarantee and subsequent paragraphs are renumbered. It is a condition of this letter of credit that it is deemed to be automatically extended without amendment for 1 year from the expiration date hereof, or any future expiration date unless at least 60 days prior to any expiration date we notify you or the transferee by registered mail or other receipted means of delivery that we elect not to consider this letter of credit renewed for any such additional period. At the time we notify you, we also agree to notify the account party and confirming financial institution, if any, by the same means of delivery. Number 4, this letter of credit is transferable. Transfers and assignments of proceeds are to be effected without charge to either the beneficiary or the transferee, assignee of proceeds. Such transfer or assignment shall be only at the written direction of the government, the beneficiary, in a form satisfactory to the issuing financial institution and the confirming financial institution, if any. 5, this letter of credit is subject to the Uniform Customs and Practice, UCP, for documentary credits, 1993 revision, International Chamber of Commerce, publication number 500, and to the extent not inconsistent therewith to the laws of, and then you would put the state of confirming financial institution, if any, otherwise state of issuing financial institution. Number 6, if this credit expires during an interruption of business of this financial institution as described in Article 17 of the UCP, the financial institution specifically agrees to effect payment if this credit is drawn against within 30 days after the resumption of our business. Sincerely, and that would be the issuing financial institution, lowercase f. The following format is used by the financial institution to confirm an ILC. then there's a line confirming financial institution's letterhead or name and address. Date, our letter of credit advice number, beneficiary, which would be the U.S. government agency, whichever one that is, issuing financial institution, issuing financial institution's LC number. Gentlemen, colon. 1. We hereby confirm the above indicated letter of credit, the original of which is attached, issued by, and that would be the name of the issuing financial institution, for drawing of up to United States dollars, and then there'd be a dollar amount, and expiring with our close of business when the expiration date or any automatically extended expiration date. 2. Draft or drafts. Draw under the letter of credit and this confirmation are payable at our office located at, and there's a blank. Number 3, we hereby undertake to honor site draft or drafts drawn under and presented with the letter of credit and this confirmation at our offices at specified herein. 4. The note is, this paragraph is omitted if used as a big guarantee and subsequent paragraphs are renumbered. It is a condition of this confirmation that it be deemed automatically extended without amendment for 1 year from the expiration date hereof or any automatically extended expiration date unless, colon, lowercase a, at least 60 days prior to any such expiration date, we shall notify the contracting officer or the transferee and the issuing financial institution by registered mail or other receipted means of delivery that we elect not to consider this confirmation extended for any such additional period, or lowercase b. The issuing financial institution shall have exercised its right to notify you or the transferee, the account party, and ourselves of its election not to extend the expiration date of the letter of credit. 5. This confirmation is subject to the Uniform Customs and Practice, UCP, for documentary credits, 1993 revision, International Chamber of Commerce publication number 500, and to the extent not inconsistent therewith, to the laws of, and then you would put the state that's confirming the financial institution. Number 6, if this confirmation expires during an interruption of business of this financial institution, as described in Article 17 of the UCP, we specifically agree to effect payment if this credit is drawn against within 30 days after the resumption of our business. Sincerely, and then they would sign with the confirming financial institution. Lowercase g. The following format shall be used by the contracting officer for a site draft to draw on the letter of credit. Site draft, city, state, date, name and address of financial institution. Pay to the order of beneficiary agency for the sum of United States and the dollar amount. This draft is drawn under irrevocable letter of credit number, and they sign with the beneficiary agency and by. So on April 9th, 2002, at 12:18 p.m., Lehman Brothers banking cartel in New York City agreed to provide prison industry leader, CCA, Corrections Corporation of America, with a new $695 million senior secured credit facility to be combined with a $150 million notes offering. The war on terrorism has created a buzz in the private prison industry. Less than 3 weeks after September 11th, a New York Post story on the for-profit private prison industry stated, quote, Americans' new wall of Homeland Security is creating a big demand for cells to hold suspects and illegal aliens who might be rounded up, end of quote. In order to prosper, prison operators need to maintain a steady flow of prisoners and prison dollars. One of the industry's tools for accomplishing this is the American Legislative Exchange Council, a powerful right-wing lobby group that helps corporations draft and enact model legislation for a price. Industry leaders CCA and Wackenhut have paid tens, if not hundreds of thousands of dollars in exchange for a privileged position on ALEC's, that's all capital letters, Criminal Justice Task Force, which CCA chairs. ALEC, in turn, not only promotes privatization, but also brags of having helped enact, quote, truth in sentencing and, quote, 3 strikes, end of quote, laws in 25 states. In addition to investing heavily in groups like ALEC and the Reason Foundation, the industry spends millions on campaign contributions. From 1995 to 2000, CCA, Wackenhut, and Cornell spent $520,000 in federal elections, and in 1998, the industry spent $540,000 on state elections, where a little money goes a long way. Corporations work on the fiscal accounting cycle because they operate using commercial debt. We as owner-principals work on the general calendar accounting year or cycle. New York City has a $6.6 billion deficit. This deficit represents unredeemable debt on the credit side of the accrual accounting system and cannot be executed to the debt side of accrual accounting ledger, except through the principal's exception. New York has therefore put its bond underwriting business up for bid. This means that New York will issue $6.6 billion in bonds and pay underwriters over $30 million in fees in the next fiscal year alone. Lehman Brothers Bank will underwrite New York's $6.6 billion deficit. An underwriter is an insurer or one who buys stock from the issuer with an intent to resell it to the public or an entity or person, especially an investment banker, who guarantees the sale of newly issued securities by purchasing all or part of the shares for resale to the public. The term underwriter derives its meaning from the former British insurance practices. When insuring their cargo, shippers would seek out investors to insure their property. The insurers would add their signatures and would write their names under those of the shipper, hence the term underwriter. Both in terms of the insurance industry and securities market, the concept of underwriting have expanded significantly since its inception. West Mutual Shippers Association out of Luxembourg, is underwriting Social Security Administration a surety, ship, contract, or bond. Now you know how they are financing the commodities and securities market and why New York City is called the Great Whore of Babylon in the book of Revelations, chapter 18, verses 10 through 24. Because she is for sale. The Corrections Corporation of America owns most of your prison systems and sells its stock and shares on the New York Stock Exchange. The major stockholder is the Payne Weber Group. They have a Dun & Bradford Street rating and are headquartered in Nashville, Tennessee at 10 Burton Hill Boulevard and can be reached at 1-800-624-2931. Their ticker symbol for their stock is capital C, capital X, capital W, underscore lowercase p, lowercase b on the New York Stock Exchange, and CXW, all capital, under business services on the New York Stock Exchange. In Berlin, Germany, their ticker symbol is CXW, all uppercase, period, uppercase B, uppercase E, and uppercase CXW, period, uppercase D, uppercase E, in Frankfurt, Germany. CCA later merged into Prison Realty Trust, a real estate investment trust that is exempt from corporate taxes if it meets certain conditions. This was a $4 billion transaction. Companies acquire U.S. Corrections Corporation. One important condition is that it distribute 95% of its income to shareholders, a provision making capital REITs attractive to investors. Prison Realty Trust failed to meet those conditions of cash flow problems. It posted a $62 million loss for 1999 and was in default on the terms of its credit facility. Wall Street was unimpressed at the company's earlier scheme to issue junk bonds. Investors are angry that Pgs.1 lost its REIT status and the related dividend. They are filing class action suits against Prison Realty Trust for false claims on Securities and Exchange Commission documents. Specifically, they are concerned about the non-disclosure of payments by Pgs.1 to CCA. Meanwhile, Prison Realty just paid a dividend on their preferred stock belonging to executives and institutional partners, which sent the common stock to new lows as shareholders realized they are not likely to see dividends soon. In April of 2000, company audits expressed doubt about the company's solvency. Shares hit a new 52-week low of 2.12 each, down from the 52-week high of $22.37. In his book, The Perpetual Prisoner Machine, see resources, Joel Dyer notes the outside one CCA facility. There is a placard with the words, quote, "Yesterday's closing stock price," end of quote. Imagine the legitimacy and confidence that are lost by people driving by seeing the stock price plummet, or even seeing, quote, "Yesterday's closing stock price, $2.12, end of quote. Together, CCA and its spin of Prison Realty Trust lost $265 million. Quote, "It's a slim chance, but bankruptcy is a possibility," end of quote, says an analyst for the First Union Securities. Localities that have contracts with the companies are concerned about whether guards will get paid and how morale or turnover will affect daily operations, including prison security. The private prison was offered a $200 million restricting plan from its current shareholder, Pacific Life Insurance Company. The private prison's largest shareholder, Dreamin Value Management, was pleased at the offer. Quote, "We always maintained that the prison business was great, but this has been a financial engineering disaster," end of quote. Shareholder lawsuits still must be settled on satisfactory terms for the deal to be finalized, but the other requirement was met with Lehman Brothers refinanced Pgs.1's $1 billion credit line. At the close of business, 26th April, the price closed below $3 a share again after briefly hitting $3.50 the previous week. Prices through the first half of May have generally been below $3 a share. On April 7th, the stock hit a new low of $2, and talks started on financial restructuring to remedy default on credit line. During the next week, stock rose $1 a share when news that their $1 billion credit line is restructured and they receive a $780 million federal contract. Instrumental in pulling off this contract was former Federal Bureau of Prisons head J. Michael Quinlan, who is now on the board of Pgs.1. The federal contract, with guaranteed 95% occupancy rate, provided financial resources to reject a restructuring offer from Pacific Life Insurance, but a Legg Mason stock analyst declared Pgs.1 an underperformer. Quinlan is now one of the top executives in the company. Because the stock has lost 75% of its value, two of the executives are leaving. but not without a $1.3 million severance. Of course, there's also been millions in attorney fees, class action lawsuits from shareholders about the merger and management fees for restructuring. Share prices bottomed out at 18 cents. Yes, 18 cents. That really inspires confidence in the justice system. They instituted a 10-for-1 split, which does not change the underlying financials of the company, but prevented them from being removed from the New York Stock Exchange. On February 23, 2000, Pacific Life Insurance Company submitted to the Board of Directors of Prison Realty Trust a shareholder-based proposal to invest in and restructure Prison Realty Trust. The shareholder proposal would involve additional value, less dilution, and potentially higher returns for existing shareholders of Prison Realty Trust than the agreement Prison Realty Trust currently has with Fortress Investment Group, LLC, the Blackstone Group, and Bank of America. Fortress Investment Group is a global alternative investment and asset management firm founded in 1998 with approximately $11 billion in equity capital. They are located at 1251 Avenue of the Americas, 16th floor, New York, New York, zip code 10020. Fortress just recently completed the acquisition of Germany's fourth largest residential housing company, Gagfah, from the German federal government's Social Security and Pension Agency. It's capital B, lowercase f, uppercase A. I can't pronounce it. It's like Bundesversich Irrungsangott. I don't know. Fewer Engels. I don't know how you say that. Just look it up. Capital B, lowercase f, capital A. The transaction, which is valued at approximately 3.5 billion euros or $4.3 billion in US, includes the assumption of 1.4 billion euros of existing financing, a $1.4 billion acquisition loan, and 700 million euros of private equity capital. Fortress, on November 15, 2004, merged with Stelmar Shipping Limited. Stelmar is an international provider of petroleum products and crude oil transportation services and is headquartered in Athens, Greece. Stelmar operates one of the world's largest and most modern Handymax and Panamax tanker fleets with an average age of approximately 6 years. Stelmar's 40-vessel fleet consists of 24 Handymax, 13 Panamax, and 3 Aframax tankers. The Blackstone Group is a private investment banking firm and describes itself as a leading global investment and advisory firm. The Blackstone Group was founded in 1985 by a group of 4, including Peter G. Peterson and Stephen A. Schwartzman. The Blackstone Group has ties to American International Group, Inc., AIG, and Kissinger Associates, Inc., Henry Kissinger. According to the Blackstone website, AIG acquired a 7% non-voting interest in the company in 1998 for $150 million and committed to invest $1.2 billion in future Blackstone-sponsored funds. Blackstone has developed strategic alliances with some of the largest and most sophisticated international financial institutions. In addition to AIG, they include Kissinger Associates, Roland Berger and partner, GmbH, and Skandaviska Enskilda Banken. The website states, the company's Blackstone Alternative Asset Management Unit handles $1 billion in hedge funds for pension giant CalPERS. John Kerry Forbes, 2004 campaign advisor Roger C. Altman was vice chairman of the Blackstone Group from 1987 through 1992, where he led the firm's merger advisory business. In December 2001, the Blackstone Group was appointed as Enron's principal finance advisor with regard to financial restructuring. The Blackstone Group is also handling the restructuring of Global Crossing. The Blackstone Group is located at 345 Park Avenue, New York, New York. In October 2004, Kissinger Associates and APCO Worldwide announced that they had formed a strategic alliance. APCO Worldwide was started by Marjorie Krauss in 1984, and she is active on the board of Group Manatep, Chair Advisory Board, the largest Russian holding company. Tuza Fund, a Fairchild technology venture from Israel. Group Manatep is an international diversified holding company and long-term Russian strategic and portfolio investor in international financial and capital markets. Kissinger Associates is located at 350 Park Avenue, New York, New York. Other groups associated with Kissinger are Kissinger McLarty Associates, Military Industrial Complex, and Oil Industry. Henry Kissinger's real name is Henry Stern, who started and trained the terrorist group, the Stern Gang, in Israel, which is now called the Mossad. He trains global terrorist groups for the FBI, CIA, and the military, which are the groups running our government at every facet of its existence. Let me read that again to you. That is very, very important. Kissinger Associates. Oh, wait a minute. That's the address. Other groups associated with Kissinger are Kissinger McLarty Associates, Military Industrial Complex and Oil Industry. Henry Kissinger's real name is Henry Stern, who started and trained the terrorist group, the Stern Gang, in Israel, which is now called the Mossad. He trains global terrorist groups for the FBI, the CIA, and the military, which are the groups running our government at every facet of its existence. Pacific Life, a long-term investor, beneficially owns approximately 4.5 million shares of Prison Realty Trust. The shareholder proposal by Pacific Life provides for additional value in the form of Series C preferred stock, approximately $2.20 per share, to be distributed to existing shareholders and potentially higher future returns, along with generating between $45 to $123 million in additional cash flow to Prison Realty Trust. Pacific Life was founded in 1868 and provides life and health insurance products, individual annuities, and group employee benefits, and offers to individuals, businesses, and pension plans a variety of investment products and services. The Pacific Life family of companies manages $300 billion in assets, making it one of the largest financial institutions in America, and currently counts 65 of the 100 largest U.S. companies as clients. Pacific Life Insurance Company is a member of the Fortune 500 group. The Prison Realty Trust, PZN, which is a real estate investment trust, a REIT, and is the world's largest private sector owner and developer. A REIT is a company that buys, develops, manages, and sells real estate assets. REITs allow participants to invest in a professionally managed portfolio of real estate properties. REITs qualify as pass-through entities, companies who are able to distribute the majority of income cash flows to investors without taxation at the corporate level, providing that certain conditions are met. As pass-through entities whose main function is to pass profits onto investors, a REIT's business activities are generally restricted to generation of property rental income. Another major advantage of REIT investment is its liquidity, ease of liquidation of assets into cash. As compared to traditional private real estate ownership, which are not very easy to liquidate, one reason for the liquid nature of REIT investments is that its shares are primarily traded on market exchanges, making it easier to buy and sell REIT assets shares than to buy and sell properties in private markets. The origins of the real estate investment trust, or REIT, date back to the 1880s. At that time, investors could avoid double taxation because trusts were not taxed at the corporate level if income was distributed to beneficiaries. This tax advantage, however, was reversed in the 1930s, and all passive investments were taxed first at the corporate level and later taxed as a part of individual incomes. Unlike stock and bond investment companies, REITs were unable to secure legislation to overturn the 1930 decision until 30 years later. Following World War II, the demand for real estate funds skyrocketed, and President Eisenhower signed the 1960 Real Estate Investment Trust tax provision, which reestablished the special tax considerations qualifying REITs as pass-through entities, thus eliminating the double taxation. This law has remained relatively intact with minor improvements since its inception. REIT investment increased through the 1980s with the elimination of certain real estate tax shelters. Investments in real estate provided investors with income and appreciation. The Tax Reform Act of 1986 allowed REITs to manage their properties directly, and in 1993, REIT investment barriers to pension funds were eliminated. This trend of reforms continued to increase the interest and value of REIT investment. Today, there are over 300 publicly traded REITs operating in the United States. Their assets total over $3 billion. Approximately 2/3 of these trade on the National Stock Exchange. REITs fall into three broad categories. Equity REITs, 96.1%. Equity REITs invest and own properties, thus responsible for the equity or value of their real estate assets. Their revenues come principally from their property rents. That's likely what this company is that owns this complex. It's likely an equity REIT, I bet money. Mortgage REITs, 1.6%. Mortgage REITs deal in investment and ownership of property mortgages. These REITs loan money for mortgages to owners of real estate or invest in purchase existing mortgages or mortgage-backed securities. Their revenues are generated primarily by the interest that they earn on the mortgage loans. Hybrid REITs, 2.3%. Hybrid REITs combine the investment strategies of equity REITs and mortgage REITs by investing in both property and mortgages. Individual REITs are available to distinguish themselves by specialization. REITs may focus their investments geographically by region, state, or metropolitan area, or in property types such as retail properties, industrial facilities, office buildings, apartments, or healthcare facilities. Certain REITs choose a broader focus, investing in a variety of types of property and mortgage assets across a wider spectrum of locations. The current REIT industry investment choices can be broken down by property. Retail 20%, residential 21%, industrial office 33.1%, specialty 2.3%, healthcare 3.8%, self-storage 3.6%, diversified 8.5%, mortgage-backed 1.5%, lodging/resort 6.1%. Federal Prison Industries, also known by its trade name Unicor, founded in 1934, is operated by the Department of Justice and is wholly owned government corporation which employs 25% of the Federal Bureau of Prisons' sentenced inmate population. Unicor is a supplier to the military during the current war in Iraq. The government has also created the Prison Industrial Complex, which is composed of the following agencies: Biometric Consortium, Border Research and Technology Center, BRTC, Bureau of Alcohol, Tobacco, and Firearms, BATF, Corrections Program Office, CPO, Counter Drug Technology Assessment Center, CTAC, Drug Enforcement Administration, DEA, Federal Bureau of Prisons, FBP, Federal Prison Industries, operated by the DOJ, also known as Unicor, Immigration and Naturalization Service, National Institute of Corrections, NIC, National Institute of Justice, NIJ, National Law Enforcement and Corrections Technology Center, NLECTC, National Technological Information Service, NTIS, Office of Correctional Education, OVAE, Office of Drug Control Policy, ODCP, Office of Law Enforcement Standards, OLES, Office of Law Enforcement Technology Commercialization, OLETC, Office of National Drug Control Policy, ONDCP, Office of Science and Technology, OSNT, Space and Naval Warfare Systems Center, San Diego, Navy SSC, San Diego, Southwest Border High Intensity Drug Trafficking Area, HIDTA, Unicor, U.S. Customs Service, U.S. Department of Defense, DoD/Biometric Management Office, BMO, U.S. Department of Homeland Security/Border and Transportation Security Directorate, BTS, U.S. Department of Justice, DOJ, U.S. Parole Commission, non-governmental entities, Alternative Monitoring Services, American Correctional Association, American Legislative Exchange Council, ALEC, Bed Brokers, BI Inc., Biometric Systems. The Biometric Foundation. Bobby Ross Group. Capital Correction Resources. Cornell Corrections. Correctionalnews.com. Corrections.com. Corrections Corporation of America, CCA. Corrections Yellow Pages. Dominion Management. Dove Development Corporation. Earl Warren Legal Institute. Federal Extradition Agency, private. General Security Service. Government-owned contractor-operated Iridian Technologies, Inc., formerly ErieScan, Inc. Juvenile and Jail Facility Management Services, Justice Policy Institute, JPI. Justice Technology Information Network, JTIN. Law Enforcement and Corrections Technology Advisory Council, LECTAC. Mace Security, Inc. Management and Training Corporation. Manhattan Institute. Marriott Management Services. Misuse of Labor. N-Group Securities. National Criminal Justice Commission. National Institute of Corrections, NIC. Open Society Institute Center on Crime, Communities and Culture. Premier Detention Services. Pintrek, Motorola. Prison Industries. The Prison Litigation Reform Act, 1996. Prison Realty Trust, merged with Corrections Corporation of America. Prison Telephone Service. AT&T, The Authority, Bell South, Max, MCI, Maximum Security, North American and Telecom. RNS Prisoner Transport. Rent a Call, See Bed Brokers. Scientific Applications and Research Associates, SARA. The Sentencing Project. Century Secured Electronic Network for Travelers Rapid Inspection, Serco Group, Inc. Stuntech, Inc. Transcore America. Urban Development Corporation. U.S. Corrections Corporation, purchased by Corrections Corporation of America. Wackenhut Corporation, Wackenhut Corrections. Other related Disinfopedia resources. Biometrics, defense contractors, eugenics, federal contractors, global detention system, global economy, globalization, military-industrial complex, surveillance industrial complex, population control, prison labor, sustainable development, timeline to global governance. What is timeline to global governance? That's the one world order, is it not? External links. Wikipedia. Carceral state. Wikipedia. Retribution justice. Wikipedia. Prison industrial complex. Disinfopedia is an encyclopedia of people, issues, and groups shaping the public agenda. It is a project of the Center for Media and Democracy. Email Bob at Disinfopedia. American Legislative Exchange Council is owned by Paul Weyrich of the Free Congress Foundation and receives financial support from all of your major corporations. They are the moving force and promoter of the National Council of State Legislatures, who prioritize criminal statutes for financial gain and profit. They are promoting public policy in regard to prize and capture law under the War Powers Act. The Reason Foundation is run by David Knott, the president, and is a think tank promoting privatization of penal institutions for private gain. They are located at 3415 South Sepulveda Boulevard, Suite 400 in Los Angeles, California. The Wackenhut Corporation is a U.S.-based division of Group 4 Falck A/S, the world's second largest provider of security services, and is based in Copenhagen, Denmark, and is the premier U.S. provider of contract services to the business, commercial, and government markets. The types and techniques of privatization are 1. Contracting out, also called outsourcing. 2. Management contracts. 3. Public-private competition, also called managed competition or market testing. 4. Franchise. 5. Internal markets. 6. Vouchers. 7. Commercialization, also referred to as service shedding. 8. Self-help, also referred to as transfer to non-profit organization. 9. Volunteers. 10. Corporatization. Number 11. Asset sale or long-term lease. 12. Private infrastructure development and operation. Cornell Corrections, Inc. is chaired by David M. Cornell, and their company's concept began December 7th, 1990. It was a rough business plan, yet the Dillon Reed Venture Capital became their first investor on February 21st, 1991. They also called Trinity Venture Capital, and Shane Rainhill is the chairman and founder. They built correctional facilities in Plymouth, Massachusetts, the other in Central Falls, Rhode Island. They have grown 33-fold in revenues and offenders under contract since that time. They have diversified and are now dependent upon development and have diversified into the 3 sectors of the business, secure, institutional. They go up to maximum security, juvenile, and pre-release. They are the only company really in the business of aggressively growing in each of the 3 sectors. Their institutional revenues are around 42%, juvenile revenues approximate 40%, and pre-release revenues are around 18%. These factors represent the outsourcing phase of the prison system. This company is currently operating in 5 different time zones and is headquartered at 1700 West Loop South, Suite 1500, Houston, Texas. Dillon Reed Venture Capital, a New York-based corporation, merged with S.G. Warburg in 1997, creating Warburg Dillon Reed. London-based UBS Warburg is the investment banking division of the Swiss giant UBS, one of the largest banks in the world. It has some 40,000 employees spread across 40 countries. This bank was started by Paul Warburg family, which owns and controls the World Bank and started the Federal Reserve System. UBS Warburg is located at 141 West Jackson Boulevard, Chicago, Illinois. Privatization is the transfer of assets or service delivery from the government sector. Prisons are nothing but warehouses for the storage of goods and chattel under commercial law. The warden is a bailee or warehouseman. Before the term admiral was used, he was called Custo Maris, warden of the sea. In some ancient records, he was called Capitanus Marit e Marum, or captain or tenant-in-chief of the maritime. who receives personal property from another as bailment. The bailer is one who provides bail as a surety for a criminal defendant's release. Also spelled bailer. Bailment is the delivery of personal property by one person, the bailer, to another, the bailee, who holds the property for a certain purpose under an express or implied in fact contract. Goods are tangible or movable property other than money, especially articles of trade or items of merchandise. The sale of goods is governed by Article 2 of the UCC. Goods means all things, including specially manufactured goods that are movable at the time of indemnification to contract for sale and future goods. The term includes the unborn young of animals, growing crops, and other identified things to be severed from real property. The term does not include money in which the price is to be paid. The subject matter of foreign exchange transactions, documents, letter of credit rights, instruments, investment property, accounts, chattel paper, deposit accounts, or general intangibles. UCC 2-102, lowercase a, 24. Go to the Payne-Weber group on any search engine or go to www.transnational.org/pays/USAs.htm. You will see the 20 largest companies: aerospace, food chains, credit card companies, banks, insurance, media, auto, biotechnology, chemical, consulting, construction, cosmetics, waste management, defense, retail, conglomerate, water, electricity, appliance, electronics, packaging, energy, school, equipment, finance, holding, hotels, real estate, computer, recreational, materials, medical, mining, fashion, motorbike, paper, private person, pharmaceutical, post, USPS, United States Postal Service, CNF Inc., printing and publishing, advertising, restaurants, healthcare, services, metal, tobacco, telecommunications, textile apparel, tourism, transportation, and staffing. This group is the United States of America and is the largest stockholder in the world in Corrections Corporation of America that owns and controls the entire world prison system through you and is funded by your commercial dishonor. Notice that the Postal Service is involved in this. Now you know why the United States of America is the plaintiff in every federal tax case. They own and run the prison system. Transnational Corporations Observatory, nonprofit organization created by Regis Castanelli in October 1999 in Marquise, France. Marquise, I don't know how you say that, France, maintains a global profile on 10,000 corporations. Everything is being run under the law merchant under UCC 1-103, section 1775.04 of Title 17 Corporations. Partnerships of the Ohio Revised Code says, quote, rules of law and equity, including the law merchant, to govern, end of quote. UCC 1-103 is quoted in the Administrative Manual of the Internal Revenue Service, put out by CCH, and says that the law of the merchant governs all sections in the Internal Revenue Code. Based on the above information, it looks like GSA and GAO are heavily involved in the accounting aspect of the prison system, which explains why they are supplying all the bond forms respecting the bid, performance, payment, and affidavit of individual surety. When your dishonor is sold within the United States, it has a 6-digit accounting number and is called a cardinal number. When it is sold at the international level, it goes ordnance or military and uses a 9-digit accounting number. This is where auto, capital T, capital R, capital I, capital S, and CUSIB come in. AutoTRIS is the Automated Forensic Traces Investigation System and was designed in the Russian Federal Center of Forensic Science using a graphical toolkit that was developed at Automation Designs and Solutions, Inc. for other software products. AutoTRIS is copyrighted and licensed to AD&S in the USA and other countries of America. This program is used as a jail management system for inmate tracking. This system also has a law enforcement module and a court management module for courtroom accounting. Every metropolitan police department and federal police have this system installed in their vehicles and is referred to as the Criminal Justice Tracking System. Xignite, Inc. designs the software that is used in AutoTRIS and is located at 1291 East Hillsdale Boulevard, Suite 211, Foster City, California. United States of America. Okay, that's the address. CUSIP is the trademark for the system that uniquely identifies securities and other instruments of general interest. The name CUSIP is derived from the ABA Committee on Uniform Security Identification Procedures. The CUSIP agency is the organization within the ABA, American Bankers Association, which is charged with the responsibility of developing, enhancing, and maintaining the system and policies necessary for uniform securities identification. CUSIP is the trademark of Standard & Poor's, which operates under a license agreement with the ABA and is located at 55 Water Street, 47th floor, New York, New York. Interestedly, this is the same address of the DTC Depository Trust Corporation and the Depository Trust Company, which is the holding and settlement company for all credit card trust accounts, and is the holder of all bonds and certificated securities for all investors, and which is the clearinghouse for all goods, commodities, and securities. It is also called or referred to as the EMCC, the MSCC, the NSCC, the DTCC, GSCC, FICC, GCN, the Global Clearing Network, and DCC and S, Defined Contribution Clearance and Settlement. These are the clearinghouses for all shares and stocks sold through the CCA and the Payne-Weber Group, aka the United States of American. I don't know if that's supposed to be the United States of America or the United States American. I think it's supposed to be America. I finally understand where the United States of America is located and who they are and why in the Blue Book put out by the ABA, American Bar Association, they are referred to as a foreign country. CUSIP also identifies the issuers of securities and other financial instruments within a standard 9-character framework and disseminating this information to the financial marketplace. I have a form from CUSIP called a private placement equity, which identifies mutual funds, preferred stock, warrant, and rights. How much do you want to bet the CUSIP and DTC is the clearinghouse for all arrest warrants, which are commercial checks under Article 3 of the UCC. I also have a form called a private placement debt, which identifies for purchase serial bonds, term bonds, currency, and sinking funds. All bonds are identified by using a CUSIP 9-digit number. I have a 26-page list with bonds, treasury bills, notes, Freddie Mac, Jenny Mae, Sallie Mae, and Fannie Mae. They are also offering TBAs, which are futures contracts on mortgage-backed pools. Working with MBSCC, the CUSIP Service Bureau developed Specialized Numbering Scheme, TBA, the Bond Market Association. Mortgage-backed securities is ownership position in a group or pool of mortgage loans. It is bonds in which interest and principal received from this pool of mortgage loans are passed through to the bondholders. TBA and CUSIPs incorporate within the number itself a securities mortgage type, Jenny Mae, Fannie Mae, Sallie Mae, and Freddie Mac. Coupon, maturity, and settlement month. For financial instruments actively traded on an international basis, which are either underwritten debt instruments or debt issues or domiciled equities outside the United States and Canada. The financial instruments will be identified by a CINS, CUSIP International Number System. The CINS number was developed in 1988 by Standard & Poor's and Telecurs USA in response to the North American securities industry's need for 9-character identifier for international financial instruments. CINS numbers appear in the International Securities Identification Directory, ISID Plus Services, which is co-produced by Standard & Poor's and Telecurs USA. To show how massive this system is, ISID Plus contains over 500,000 global financial instruments and cross-references all major national numbering systems. ISID Plus has been designed to minimize the impact on back-office systems and operations, while facilitating cross-border communications among global custodians, depositories, banks, securities organizations, and exchanges. CINS numbers employ the same number, 6 characters, issue, 2 characters, and check digit. Concept espoused by the CUSIP numbering system. The first position of a CINS code is always represented by an alpha character, signifying the issuer's country code, domicile, or geographic region. The National Association of Insurance Commissioners, NAIC, in October 1988 mandated the use by issuers of a Uniform Private Placement Number, a PPN, to identify investments in their annual statements filed with the state regulatory authorities. Standard & Poor's CUSIP service was selected by the NAIC to create, assign, and administer the PPN system primarily for the insurance industry. At the international level, there is EPIM, the European Pre-Issuance Messaging, which is a central messaging hub linking the parties involved in the issuance of European commercial paper, ECP, including banks, dealers, issuing and paying agents, securities, depositories, and numbering agencies. EPIM was launched as a cooperative effort by Euroclear, Clearstream International, and DTCC. Omega LLC, a joint venture company owned equally by the Depository Trust and Clearing Corporation DTCC, and Thomson Financial, is the leading of complete global trade management services. A unique partnership between the securities industry's leading utility and the commercial sector. Omega is industry-backed and market-oriented. Through its integrated suite of intelligent trade management solutions, SM. I have the Articles of Incorporation of the Association of National Numbering Agencies, or ANNASC. The registered office is located and established at 6 Avenue de Schiphoel, 1140 Brussels, Belgium. The object of ANNA is to maintain and promote the standards of International Standard ISO 6166, as amended from time to time hereafter the standard. I bet that this standard number 6166 is the number of a man, and his number is 666, and is talked about in the Revelations 13 and 18, and whose purpose under Article 3 is to carry out any commercial, financial, or civil transactions directly or indirectly related to the objects of ANNA. Under Article 5, ANNA has unlimited capital through BIS, Bank for International Settlements, CCA, ALEC, Wackenhut, Cornell Corrections, Reason Foundation, Dillon Reed Venture Capital, S.G. Warburg, UBS Warburg, Warburg Dillon Reed, and the Payne Weber Group. Article 29, ANNA, has a list of all public fines, shares, stocks, bonds, and other securities composing ANNA's portfolio. I think ANNA is owned by the Order of Jesuits out of Rome, Italy, which is run by Count Hans Kolvenbach, the head general, Pontiff and Gregorian Council for the Order of Jesuits, and he is called the Black Pope, who owns and controls all prisons, penal institutions, and banks. ANNA also assigns the ISIN, International Securities Identification Number. The first character, category, equities, debt instruments, rights, options, futures, others. The second character, group within category, example, equities into shares, preferred shares, etc. The third to sixth character, attributes for further description and grouping. The Bank for International Settlements is at the apex of all of the world's central banks, since they control and dictate monetary policy worldwide. In the late 1990s, they set up a new structure called the Financial Stability Forum, which brought together the G7 central bank ministers, G7 finance ministers, their respective securities and exchange commissions, the Comptroller of the Currency and FDIC, along with the IMF and the World Bank. This represents a further integration of the economies, policies, and movement of monies and investments. Furthermore, in addition to the central banks, there is the Group of Eight, which is comprised of the heads of state from the United States, Canada, Germany, Japan, Italy, France, Great Britain, and Russia. They have been meeting since 1975, when they were only 5 countries. Russia is the most recent country to join. They participate fully in every area with the exception of finance, where they only participate in financial terrorism. For 22 years, the G7 finance ministers met alone. Then in 1998, they were joined by the central bank ministers. They are private corporations established in every country to manage and control that country's monetary system. This makes the Treasury Secretary of the United States a puppet of the Federal Reserve, a private corporation. The U.S. has changed the control of our banking system by repealing the Glass-Steagall Act in 1999 that allowed banks to buy brokerage firms and insurance companies. That set the tone for other countries to follow suit. Furthermore, with the establishment of the World Trade Organization Financial Services Agreement, which demands that all countries allow foreign banks, brokerage firms, and insurance companies to enter their market, they chipped away at national financial sovereignty. Since the central banks hold the currency of other countries, all that has to be done in order to destroy a country is to sell their currency at the same time. Therefore, as a result of the global volatility, which I believe was a result of the central banks selling the aforementioned country's currency, the Financial Stability Forum was set up as a further layer and deeper integration of the global economies. Also contributing to the new financial architecture is the rise of multinational and transnational corporations, mergers and acquisitions, country privatization of its assets such as railroads, agriculture, banks, airlines, telephone companies, etc. Furthermore, the rise of public-private partnerships, which is a merger between government and business, also known as fascism, has contributed to a changed financial landscape. In addition, there is the move towards a global stock exchange, the establishment of a world's customs organization, and open skies between countries. Why is privatizing prisons so appealing to federal, state, and local governments? As The Nation put it, the selling point was simple. Private companies could build and run prisons cheaper than the governments. Unfettered American capitalism would produce a better feder, saving cash-strapped states millions of dollars each year, while simultaneously generating huge profits. The Nation explains this miracle would be accomplished. Private prisons receive a guaranteed per diem fee for each prisoner, regardless of the actual costs. Each dime they don't spend on food or medical care for prisoners or on wages and training for the guards is a dime that they can pocket. Most guards in private and public prisons belong to the LEOU, which is part of the American Federation of State, County, and Municipal Employees, AFSCME. I have a pointed question for you. Why aren't we as principals on the private side of the accounting cycle using our exemption priority to discharge all this public debt under the Uniform Exception Act, Section 3? Exemption means protected, and exemption means protection from subjection to a judicial lien, process, or proceeding to collect a debt. The answer is we are all double-minded and we do not know who we are in a commercial setting. Every individual in prison is in there because of a commercial dishonor. A person who doubts is thinking about two different things at the same time and can't make up his mind about anything. Or as King James Version says, quote, a double-minded man is unstable in all his ways, end of quote. James 1:8. Let us regain and claim our honor and status as the principal with primary responsibility on obligations for discharge on the public and payment on the private. Through our exemption as principal, we can use the Standard Form 24 bid bonds, see Title 48, Section 28.101, performance bonds, see Title 48, Section 28.102-1, and 28.106-3, lowercase b. Standard Form 25, and payment bonds, Standard Form 25A, see Title 48, Sections 28.102-1 and 28.106-3, lowercase b. Form 28, Affidavit of Individual Surety, see Title 48, Section 28.102-1 and 28.106-3, lowercase b, issued by GSA under the Comptroller General to discharge any debts. Bid bonds are usually purchased by brokerage houses and insurance companies. Optional Form 90, Release of Lien on Real Property, see Title 48, Section 28.203-5, and Optional Form 91. Release of personal property from escrow, see Title 48, Section 28.203-5. These bonds can be used to release the liens imposed by the bid, performance and payment bonds, and affidavit of individual surety. This is very important to write down. I need to pee and then I'm going to write it down. We all need to start discharging. We need to start using our exemptions, and the whole prison industry collapsed. All right, let's see here. Let's stop that for a minute. Okay, I think I'm picking up where I left off. An irrevocable letter of credit under Title 48, Section 52.228-14 can be used in lieu of a bid bond. A revocable letter of credit, ILC, as used in this clause, means a written commitment by a federally insured financial institution to pay all or part of a stated amount of money until the expiration date of the letter, upon presentation by the government, the beneficiary, of a written demand therefor. Neither the financial institution nor the offeror contractor can revoke or condition the letter of credit. B. If the offeror intends to use an ILC in lieu of a bid bond, or to secure other types of bonds such as performance and payment bonds, the letter of credit and letter of confirmation formats in paragraphs E and F of this clause shall be used. Under Section G of the clause, at 52.228/14, the contractor can draw on the ILC using the site draft draw up in Section G. By legal definition, all of your federal and state statutes are bonds or obligations of record and are represented in the courtroom by the recognizance bond, which is a bond of record or obligation for the payment of debt. A condensed version of what is going on is that the CCA, as a corporation, creates or issues stock certificates based on prison population. goods or chattel as they are called in commercial law, the underwriter is the one who buys the stock from the issuer, the CCA, with intent to resell it to the public or an entity or person, which is usually an investment banker. The investment banker purchases all or part of the shares of the stock for resale to the public in the form of newly issued investment securities based on the shares of the stock. Brokerage houses and insurance companies bid on the investment securities with a bid bond issued by the GSA. The bid bond is then indemnified by a surety company through performance and payment bonds. The bid, performance, and payment bonds are then underwritten by an affidavit of individual surety through the banks as investment securities for resale to the public. The institutional holders who own most of the shares are the FMR, Fidelity Management and Research Corporation, owning 3,084,024 shares at a value of $109,791,254. 2. Legg Mason Inc., owning 1,235,563 shares valued at $43,986,042. 3. Barclays Bank PIC, 1,041,671 shares valued at $37,083,487. There are 17 more corporations owning various amounts of shares at varying dollar values. These can be viewed by going to http://finance.yahoo.com/q/MH?S=CXW. The top insider and Rule 144 holders are 1. Joseph V. Russell. 2. John D. Ferguson. 3. Michael J. Quinlan. 4. Jimmy Turner. And 5. John Horn. As you can see by the above information, this system permeates every fabric of our society. This treatise represents about 700 hours of brainstorming. Currently, global terrorism is being funded by the prison system and the state's retirement fund. Go to www.divestterror.org. This is a 115-page treaty on the terrorism investments of the 50 states. Go to a search engine and type in U.S. courts. Go to a court links and click, which shows a map of the circuit courts. Click on 7th Circuit. A list of the 7th and 8th Circuit courts will appear. Click on Illinois Northern District. Then click on the clerk's office. Then go to Administrative Services. Then to Financial Department. You will see Criminal Justice Act, Post-Judgment Interest Rates, and List of Sureties. Click on Sureties. It will take you to fms.treas.gov. There, on left side, you will see sureties listing, admitted reinsurers, and forms. Click on Forms. You will see Reinsurance Agreement for a Miller Act Performance Bond, SF-273, and a SF-274 Payment Bond, and a Reinsurance Agreement in favor of the United States, SF-275, and a list of admitted reinsurers, pools and associations, and Lloyd's syndicates. You will also see a list of Department of Treasury's listing of approved sureties, Department Circular 570. You know what I'm thinking here? U.S. district courts are buying up the state court default judgments. When you refuse to pay or dishonor the debt, contractors and insurance companies are bidding on the default judgments with a bid bond. Then a reinsurance company comes in and purchases a performance bond as a surety for the bid bond. The performance bond is then underwritten by a payment bond. The payment bond is then underwritten by an affidavit of individual surety. This is usually done by an investment company or investment banker. When these bonds are pulled, they become mortgage-backed securities or surety bonds. They are then put on the bond market through TBA, the Bond Association. These bonds are also sold as investment securities through brokerage houses or insurance companies. Secure is one of your biggest international securities companies and is located in South Africa and have acquired Gray Security Services. Securicur was formed from the merger between Securicur PIC and Group 4 Falk, which was completed in July 2004. Securicur operates in 50 different countries. Reinsurance is defined as insurance of all or part of one insurer's risk by a second insurer who accepts the risk in exchange for a percentage of the original premium. This is all Admiralty Maritime at its finest, also termed reassurance. The term reinsurance has been used by courts, attorneys, and text writers with so little discrimination that such confusion has arisen as to what that term actually connotates. Thus, it has so often been used in connection with transferred risks, assumed risks, consolidations and mergers, excess insurance, and in other connections that it now lacks a clear-cut field of operation. Reinsurance to an insurance lawyer means one thing only: the ceding by one insurance company to another of all or a portion of its risks for a stipulated portion of the premium, in which the liability of the reinsurer is solely to the reinsured, which is the ceding company, and in which contract the ceding company retains all contact with the original insured and handles all matters prior to and subsequent to loss. 13A, John Allen Appleman and Jean Appleman, Insurance Law and Practice, Section 7681 at page 479 to 480, 1976. The laying off of risk by means of reinsurance traditionally serves three basic purposes. First, reinsurance can increase the capacity of the insurer to accept risk. The insurer may be enabled to take on larger individual risks or a larger number of smaller risks, or a combination of both. Secondly, reinsurance can promote financial stability by improving the adverse consequences of an unexpected accumulation of losses or of a single catastrophic losses, because these will, at least in part, be absorbed by reinsurers. Thirdly, reinsurance can strengthen the solvency of an insurer from the point of view of any regulations under which the insurer must operate, which provide for a minimum solvency margin, generally expressed as a ratio of net premium income over capital and free reserves. P.T. O'Neill and J.W. Wolinecki that's the Law of Reinsurance in England and Bermuda for 1998. All of the performance and payment bonds are regulated and controlled by FAR, Federal Acquisition Regulations, which is under 48 CFR 28.202-1 and 53.228H. These bonds are being used in cases where it is desired to cover the excess of a direct writing company's underwriting limitation by reinsurance instead of co-insurers on Miller Act performance bonds running to the United States. These FAR regulations come in 2 volumes. Volume 1 is approximately 1,326 pages. Volume 2 is 823 pages long. These should be consulted and read before these bonds are used. The Miller Act is found in Title 48, the Miller Act is found in Title 40, USCA Sections 270A, 270D-1, and is federal law requiring the posting of performance and payment bonds before an award is made for a contract for construction, alteration, or repair of a public work or building. The surety company issuing these bonds must be listed as a qualified surety on the Treasury list, which the U.S. Department of the Treasury issues each year. I believe that the prisons are repository institutions or facilities for securities, prisoners. As collateral for the public and national debt, the prisoners represent asset or repository money for the bid, performance, and payment bonds. The prisons are referred to as credit facilities, institutions, or repositories. They function essentially the same way that a depository bank does under 17 CFR Section 450. The prisons are acting in the capacity of a fiduciary or custodian over government securities or otherwise for the account of a customer, and that are not government security brokers or dealers as defined in Section 3, lowercase a, 44 of the Securities Exchange Act of 1934. That's 15 U.S.C. 78 CA 43 through 44. The regulations in subchapter B are promulgated by the Assistant Secretary, Domestic Finance, pursuant to a delegation of authority from the Secretary of the Treasury. The office responsible for the regulations is the Office of the Commissioner, Bureau of the Public Debt. I think I need to take a break here just for a second because I need to write this down. All right, let's pick up. Sureties and surety bonds are covered in Title 31, Sections 9301-9309. The bid, performance, payment bonds, and affidavit of individual surety fall into the category of surety bonds under these provisions. Under Section 9303, government obligations may be substituted for surety bonds. Government obligations are defined as public debt obligations of the United States government and an obligation whose principal and interest is unconditionally guaranteed by the government. The bid, performance, payment bonds, and affidavit of individual surety, in addition to being sold on the Commodities and Securities Exchange as pooled mortgage-backed securities and cleared for settlement through the FICC, Fixed Income Clearing Corporation, who is the holder until the bonds are sold, are also being pledged as collateral for funds and a line of credit at the discount window or the open market trading desk of Freddie Mac, Fannie Mae, Sallie Mae, Ginnie Mae, or your local Federal Reserve Bank. All discount window advances must be secured by collateral acceptable to the Reserve Bank. The following types of assets are most commonly pledged to secure discount window advances. 1. Obligations of the United States Treasury. 2. Obligations of U.S. government agencies and government-sponsored enterprises. 3. Obligations of states or political subdivisions of the U.S. 4. Collateralized mortgage obligations. 5. Asset-backed securities. 6. Corporate bonds. 7. Money market instruments. 8. Residential real estate loans. 9. Commercial, industrial, or agricultural loans. 10. commercial real estate loans. 11. Consumer loans. 12. Check your local reserve bank if you have any questions about other types of collateral. The Federal Reserve System discount window collateral margins table includes valuation margins for the most commonly pledged asset types. Assets accepted as collateral are assigned a lend-able value, market or face value multiplied by the margin, deemed appropriate by the Federal Reserve Bank. See the attached schedules. The Treasury Department issues certificates of authority to insurance companies who submit a financial statement to the Department of Treasury. The reinsurance company's limitation on liability is determined and predicated on 10% of a policyholder's surplus, retained by earnings from capital surplus. The published underwriting limitation is on a per bond basis, but does not limit the amount of a bond that a company may write. Companies are allowed to write bonds with a penal sum over their underwriting limitations as long as they protect the excess amount with reinsurance, coinsurance, or other methods as specified in Treasury Circular 297, revised September 1st, 1978, 31 CFR 223.10-11. Treasury refers to a bond of this type as an excess risk. When excess risks on bonds in favor of the United States are protected by reinsurance, such reinsurance is to be effected by use of a federal reinsurance form to be filed with the bond or within 45 days thereafter. In protecting such excess risks, the underwriting limitation in force on the day in which the bond was provided will govern absolutely. If you read DeLavio vs. Boyd, federal case number 3776, you will find out that all insurance is of Admiralty Maritime Law, and the Huntress, federal case number 6914, 2 Ware Dav 8289 says that all revenue is Admiralty Maritime Law. Under King Charles II, revenue cases had been heard and tried in the colonies by the Vice Admiralty. Read pages 988 and 989 of the Huntress. Charles Townshend, who passed the Townshend Act in 1767 and who was the Lord High Admiral on the British Board of Trade, caused the American Revolution due to the high tariffs, duties, imposts, and excises imposed on the colonists on imports from London, England. By talking with a broker named Jim McFadden for A.G. Edwards I, found out that the bond register and paying agent for the county of Cuyahoga is Frank Lamb, a trustee for Huntington National Bank at 917 Euclid Avenue, Cleveland, Ohio. I also found out that Lisa Jennings of J.P. Morgan Bank in Cleveland, Ohio is the transfer agent for bonds, and Holly Pattison of National City Bank is also a transfer agent. I spent 30 minutes on the phone with Robert Duke, who is the Director of Underwriting for the Surety Association of America under Circular 570 for the Department of Treasury, who's located in Washington, D.C. I went through Circular 570 of the Department of Treasury and called several of the admitted reinsurance companies through their underwriting department and found out they knew absolutely nothing about reinsurance relative to bid, performance, and payment bonds. This fact leads me to believe that in addition to being a repository bank with prisoners being the assets, collateral, or securities for the bid, performance, and payment bonds, the prisoners are the actual reinsurance, or surety, and their sentence represents the valued and marketable risk involved with the materials, supplies, and cost factors involved with the guaranteed performance and payment relative to the bonds. This is termed assumed risk in insurance and represents a present peril hazard or danger of loss due to their dishonor and default judgment in the court. That is why there is a penal sum or clause attached to each bond for non-performance and payment of the bonds. Since everybody on the public or debt side is bankrupt or insolvent, how can they assume a liability risk? They can't. That is why they have to look to the exempt priority private asset side of the accounting ledger to assume reinsurance or risk. You can't pay a debt or assume a risk with a debt instrument. This can only be done with asset collateral through goods, which are prisoners, under mercantile, civil, and commercial law. When a corporation wants to build or perform construction, he receives bids from a contractor. If the contractor is awarded the bid, the corporation, who is the owner and obligee, then requires that the contractor submit a bid bond. The contractor then becomes the principal obligor. He is then required to get a reinsurance company to act as surety on the bid bond, and then a performance bond is issued to guarantee cost of material and supplies. The reinsurance company, who is acting as surety for the bid bond, also acts as the underwriter through a payment bond. An affidavit of individual surety is used as a surety for the bid, performance, and payment bonds. The bid bond is a three-party obligation with the obligee as the owner of the bid, performance, and payment bonds. The Surety Association of America is a voluntary, nonprofit, unincorporated association of companies engaged in the business of suretyship. SAA represents more than 500 companies that collectively underwrite the vast majority surety and fidelity bonds in the United States, as well as a number of foreign affiliates. SAA is licensed as a rating or advisory organization and has been designated as a statistical agent by all the states except Texas for the reporting of fidelity and surety experience. The National Association of Surety Bond Producers is the international organization of professional surety bond producers and brokers. NASBP represents more than 5,000 personnel who specialize in surety bonding, provide performance and payment bonds for the construction industry, and issue other types of surety bonds, such as license and permit bonds for guaranteeing performance. NASBP's mission is to strengthen professionalism, expertise, and innovation in surety and to advocate its use worldwide. Oh my God, this is like insane. Everybody needs to fucking read this. Well, I'm going to put this up on my YouTube and my Rumble because people fucking need to hear this. Beep, 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 beep. Too many F's. I also believe that the bid bonds are being used to purchase commercial items, commercial paper, such as court judgments. This is done through GSA SF Form 1449, contract form, and is a rated order under DPAS, Defense Priorities and Allocation System. See 15 CFR 700. This is under the National Security Industrial Base Regulations. This is all under the executive branch, under the president and military. Word definitions relative to bonds. 1. Holder is the owner of a security. See bondholder. 2. Transfer agent. the person or entity that performs the transfer function for an issue of registered municipal securities. This person or entity may be the issuer, an official of the issuer, or a third party engaged by the issuer to act as its agent. The trustee under a trust indenture also acts as a transfer agent. Compare registrar, see registered bond, transfer, trustee. Registrar, the person or entity responsible for maintaining records on behalf of the issuer that identify the owner of a registered bond issue. The trustee under a trust indenture often also acts as registrar. Compare transfer agent, see bond register, trustee. Bond register, a record kept by a transfer agent or registrar on behalf of the issuer that lists the names and addresses of the holders of the registered bonds. See bondholder, registered bond, registrar, transfer agent. 5. Issuer, a state, political subdivision, municipality, or government agency or authority that raises funds through the sale of municipal securities. 6. Underwriter, a broker, dealer that purchases a new issue of municipal securities from the issuer for resale in a primary offering. The underwriter may acquire the securities either by negotiation with the issuer or by award on the basis of competitive bidding. Compare placement agent, see competitive sale, negotiated sale, primary distributor, primary offering, syndicate, S-U-N-D-I-C-A-T. Was that right, or is it supposed to be syndicate? I'm not sure. Probably syndicate. 7. Settlement, delivery of and payment for a security. Compare clearance, see delivery date, good delivery. 8. Clearance, the process of delivering securities from a seller to a buyer, either directly or through their agents. Compare settlement. 9. Bond proceeds, the money paid to the issuer by the purchaser or underwriter of a new issue of municipal securities. These monies are used to finance the project or other purpose for which the securities were issued and to pay certain costs of issuance as may provided in the bond contract or bond purchase agreement. See net proceeds. 10. Bond purchase agreement, BPA. The contract between the underwriter and the issuer setting forth the final terms, prices, and conditions upon which the underwriter purchases a new issue of municipal securities in a negotiated sale. A conduit borrower also is frequently a party to the bond purchase agreement in a conduit financing. The bond purchaser agreement is sometimes referred to as the purchase agreement or, less commonly, the underwriting agreement. See negotiated sale, underwriting agreement, written award. 11. Conduit borrower, a borrower of bond proceeds in a conduit financing. See conduit financing, obligor. 12. Conduit financing, the issuance of municipal securities by a governmental unit, referred to as the conduit issuer, to finance a project to be used primarily by a third party, usually a for-profit entity engaged in private enterprise or a 501c3 organization referred to as the conduit borrower. The security for this type of issue is customarily the credit of the conduit borrower or pledged revenues from the project finance, rather than the credit of the conduit issuer. Such securities do not constitute general obligations of the conduit issuer because the conduit borrower is liable for generating the pledged revenues. Industrial development bonds, multifamily housing revenue bonds and qualified 501c3 bonds are common types of conduit financing. See housing revenue bond, multifamily housing revenue bonds, industrial development, private activity bonds. 13. Award. The official acceptance by the issuer of a bid or offer to purchase a new issue of municipal securities by an underwriter. The date of the award is generally considered the sale date of an issue. See bid, bond purchase agreement, written award, compare verbal award. 14. Beneficial owner. The person to whom the benefits of ownership of given securities accrue, even though the securities might be held by or in the name of another person or held in an account over which another person has investment discretion. For example, a securities firm might hold securities in street name, in its vaults, or at a securities depository, with the beneficial owners of the securities only designated on the firm's records. Compare bondholder. 15. Depository. A registered clearing agency that provides immobilization, safekeeping, and book entry clearance and settlement services to its participants. Compare clearing corporation. See registered clearing agency. 16. Book entry only. BEO. Or book entry security. A security that is not available to purchasers in physical form. Such a security may be held either as a computer entry on the records of a central holder, as is the case with certain U.S. government securities, or in the form of a single global certificate. Ownership interests of and transfers of ownership by investors are reflected solely by appropriate books and record entries. Most municipal securities issued in recent years have been in book entry only form. Compare certificated security. Immobilized security. See global certificate. 17. Global certificate. A single certificate, sometimes referred to as a jumbo certificate, representing an entire maturity of an issue of securities. Such certificates are often used in book entry systems. The issuer issues a global certificate that is then lodged in the facilities of a depository or other book entry agent and kept safely by the agent until maturity. The securities are available to beneficial owners only in book entry form, and no certificates can be obtained. Compare immobilized security. See book entry only. Immobilized security. A physical security that is held in a central depository for the account of its beneficial owner, but that may be withdrawn from the depository in physical form. Immobilized securities may be transferred when sold by entries on the record of the depository or by withdrawal of actual certificates. Compare book entry only, global certificate. 19. 501c3 organization. An organization organized by the Internal Revenue Service as a not-for-profit organization. A 501c3 organization can borrow funds to finance projects on a tax-exempt basis through a conduit issuer. Examples include not-for-profit colleges and universities, hospitals, museums, and retirement communities. See conduit borrower. Private activity, qualified 501c3 bonds. Isn't that what like all these churches are and like the whole Scientology? Is that how they afford to buy all their properties? It's all tax-free. 20. Municipal securities. A general term referring to securities issued by local government subdivisions such as cities, towns, villages, counties, or special districts, as well as securities issued by states, political subdivisions, or agencies of states. A prime feature of these securities is that interest or other investment earnings on them usually are excluded from gross income of the holder for federal income tax purposes. Issuers of municipal securities are exempt from most federal securities laws. Compare taxable municipal security. 21. Registered clearing agency, an organization registered with the Securities and Exchange Commission pursuant to Section 17A of the Securities Exchange Act of 1934 that provides specialized systems for the confirmation, comparison, clearance, and settlement of securities transactions. See National Securities Clearing Corporation. 22. National Securities Clearing Corporation, NSCC, a clearing corporation. See Clearing Corporation, Depository Trust, and Clearing Corporation. 23. Clearing Corporation, a registered clearing agency that provides specialized comparison, clearance, and settlement services for its members. A clearing corporation typically offers services such as automated comparison systems and transaction netting systems. Compare depository. See National Securities Clearing Corporation, Registered Clearing Agency. 24. Depository Trust and Clearing Corporation, DTCC, the entity formed by the merger of Depository Trust and National Securities Clearing Corporation. DTCC facilitates the clearance and settlement of securities transactions. 25. Authority, a unit or agency of government or a separately established not-for-profit entity formed on behalf of a governmental entity established to perform specialized functions. In some cases, authorities have the power to issue debt that is secured by the lease rental payments made by a governmental unit using the facilities constructed with bond proceeds. In other cases, authorities issue private activity bonds for the purpose of making the proceeds available to qualified private entities for use as permitted under the federal tax laws. Examples of such conduit authorities include health facilities authorities, industrial development authorities, and housing finance authorities. An authority may function independently of other governmental units, or it may depend upon other units for its creation, funding, or administrative oversight. Authorities other than conduit authorities usually are financed by service charges, fees, or tolls, although they also have taxing powers. Conduit authorities generally are financed by fees payable by conduit borrowers, either paid directly by the borrower or under the bond contract. See conduit issuer. 26. Conduit issuer, an issuer of municipal securities in a conduit financing. See authority, conduit financing. 27. Private activity bond, PAB. A municipal security, the proceeds of which are used by one or more private entities. A municipal security is considered a private security bond if it meets either of two sets of conditions set out in Section 141 of the Internal Revenue Code. A municipal security is a private activity bond if, with certain exceptions, more than 10% of the proceeds of the issue are used for any private business use. The private business use text. And the payment of the principal of or interest on more than 10% of the proceeds of such issue is secured by or payable from property used for a private business use. The private security or payable test or payment test. A municipal security also is a private activity bond if, with certain exception, the amount of proceeds of the issue used to make loans to non-governmental borrowers exceeds the lesser of 5% of the proceeds or $5 million, the private loan financing test. Interest on private activity bonds is not excluded from gross income for federal income tax purposes unless the bonds fall within certain defined categories. They're called qualified bonds or qualified private activity bonds, as described below. Most categories of qualified private activity bonds are subject to the alternative minimum tax. The following categories of private activity bonds are qualified bonds under federal tax 28. Exempt facility bonds. Private activity bonds issued to finance various types of facilities owned or used by private entities, including airports, docks, and certain other transportation-related facilities. Water, sewer, and certain other local utility facilities, solid and hazardous waste disposal facilities, certain residential rental projects, including multifamily housing revenue bonds, and certain other types of facilities. Enterprise zone bonds are also considered exempt facility bonds. See enterprise zone bond, housing revenue bond, multiple family housing revenue bonds. 29. Qualified 501c3 bonds. Private activity bonds issued to finance a facility owned and utilized by a 501c3 organization. Qualified 501c3 bonds are not subject to the federal alternative minimum tax. 30. Qualified mortgage bonds. Private activity bonds issued to fund mortgages to finance owner-occupied residential property. Qualified mortgage bonds are often referred to as single-family mortgage revenue bonds. See housing revenue bond, single-family mortgage revenue bonds. 31. Qualified redevelopment bonds. Private activity bonds issued to finance certain acquisition, clearance, rehabilitation, and relocation activities for redevelopment purposes by a governmental entity in designated blighted areas. Qualified redevelopment bonds are payable from general taxes or from tax increment revenues. See tax increment bond. 32. Qualified small issue bonds. Private activity bonds issued to finance manufacturing facilities. Qualified small issue bonds may be issued on a tax-exempt basis in an amount up to $1 million, taking into account certain prior issues, or an amount up to $10 million, taking into account certain capital expenditures incurred during the 3 years prior and the 3 years following the issuance of such bonds. 33. Qualified student loan bonds. Private activity bonds issued to finance student loans for attendance at higher education institutions. 34. Qualified veterans mortgage bonds. Private activity bonds that are general obligations of a state issued to fund mortgage loans to finance owner-occupied residential property for veterans. The ability of states to issue new and refunding qualified veterans mortgage bonds on a tax-exempt basis is limited. International Bill of Exchange. In the Open Market Trading Desk and the Investing Trading Glossary, a bill of exchange is defined as a general term for a document demanding payment. This says it is all if you have wisdom and understanding. Sometimes the obvious escapes everybody. The word bill is an alteration of the Latin word bulla in its medieval sense. In classical Latin, bulla was a bubble, a boss, a stud, an amulet for the neck. Whence in medieval Latin, a seal, especially the seal appended to a charter, etc. Hence, transferred sense, a document furnished with a seal. Example, a charter, a papal bull, and by extension, an official or formal document. A bill, schedule, memorandum, note, paper. It was in these latter senses that bulla became in England bulla billet. Being a word of common use, bulla was probably pronounced with U, passing into English Y and I, though no direct evidence of this has been found. So the Oxford English Dictionary, this explanation is not convincing, nor would it even if bill or bull had originally conveyed the same or similar meaning. At least up to the end of the 14th century, the two words almost always carried meaning that were respectively inconsistent with each other. A bull was a sealed document setting forth something or other in an authoritative manner. A bill, on the other hand, so far as one can gather from the evidence of contemporary literature, seems to have carried the meaning of a humble petition for remedy of a stated grievance. The word occurs several times in this sense, and as far as I can find, in this sense only, in Gower and William Langland. Under Title 18, Section 513A, the term security as defined in the Electronic Fund Transfer Act under 916C has been amended and moved to Title 15, Section 78C, subsection 10, where it says that any currency, note, draft, bill of exchange, or banker's acceptance which has a maturity at the time of issuance of not exceeding 9 months, exclusive of days of grace or any renewal thereof, the maturity of which is likewise limited, is not included in the definition of a security. Acceptance. For Black's Law Dictionary, 8th edition, a negotiable instrument, especially a bill of exchange, that has been accepted for payment. There are 3 elements of an acceptance: 1, honor; 2, value; 3, consideration. An acceptance for honor is an undertaking not by a party to the instrument, but by a third party, for the purpose of protecting the honor or credit of one of the parties, by which the third party agrees to pay the debt when it becomes due if the original drawee does not. This type of acceptance ensures to the benefit of all successors to the party for whose benefit it is made. Also termed acceptance supra protest. Acceptance for honor supra protest. Cases, bills, and notes, Key 71, CJS Bills and Notes, Letters of Credit, Section 37. Acceptance for honor supra protest is an exception to the rule that only the drawee can accept a bill. A bill which has been dishonored by non-acceptance and is not overdue may, with the consent of the holder, be accepted in this way for the honor of either the drawer or an endorser, i.e., to prevent the bill being sent back upon the drawer or endorser as unpaid, by a friend placing his own name upon it as an acceptor of the whole or part only of the amount of the bill. After a protest has been drawn up, declaratory of its dishonor by the drawee. Similarly, where a bill has been dishonored by non-payment and protested, any person may intervene and pay it supra protest for the honor of any person liable thereon, the effect being to discharge all parties subsequent to the party for whose honor it is paid. Two Stevens Commentaries on the Law of England, 202 through 203. L. Crispin, Warmington edition, 21st edition, 1950. 3-303, Value and Consideration. A. An instrument is issued or transferred for value if 1. The instrument is issued or transferred for a promise of performance to the extent the promise has been performed. 2. The transferee acquires a security interest or other lien in the instrument other than a lien obtained by judicial proceeding. 3. The instrument is issued or transferred as payment of or as security for an antecedent claim against any person, whether or not the claim is due. 4. The instrument is issued or transferred in exchange for a negotiable instrument. Or 5. The instrument is issued or transferred in exchange for the incurring of an irrevocable obligation to a third party by the person taking the instrument. B. Consideration means any consideration sufficient to support a simple contract. The drawer or maker of an instrument has a defense if the instrument is issued without consideration. If an instrument is issued for a promise of performance, the issuer has a defense to the extent performance of the promise is due and the promise has not been performed. If an instrument is issued for value, as stated in subsection A, the instrument is also issued for consideration. The definition of negotiable instrument defines the scope of Article 3, since Section 3-102 states, this article applies to negotiable instruments. The definition in Section 3-104A incorporates other definitions in Article 3. An instrument is either a promise, defined in Section 3-103A 12, or order, defined in Section 3-103A 8. A promise is a written undertaking to pay money signed by the person undertaking to pay. An order is written instruction to pay money signed by the person giving the instruction. Thus, the term negotiable instrument is limited to a signed writing that orders or promises payment of money. Money is defined in Section 1-201, Section 24, and is not limited to United States dollars. It also includes a medium of exchange established by a foreign government or monetary units of account established by an intergovernmental organization or by agreement between two or more nations. Universal Convention on International Bills of Exchange or International Promissory Notes, December 8, 1988. And Clearfield Trust Company v. United States, that's 318 U.S. 363, 1943. The court held that if the United States is a party to an instrument, its rights and duties are governed by federal common law in the absence of a specific federal statute or regulation in United States v. Kimbell Foods, Inc. 440 U.S. 715, 1979. The court stated a three-pronged test to ascertain whether the federal common law rule should follow the state rule. In most instances, courts under the Kimbell test have shown a willingness to adopt the UCC rules in formulating federal common law on the subject. In Kimbell, the court adopted the priorities rules of Article 9. In 1989, the United Nations Commission on International Trade Law, UNICTROL, completed a convention on international bills of exchange and international promissory notes. If the United States becomes a party to this convention, the convention will preempt state law with respect to international bills of exchange and notes governed by the convention. Thus, an international bill of exchange or promissory note that meets the definition of instrument in Section 3-104 will not be governed by Article 3. If it is governed by the convention, that convention applies only to bills and notes that indicate on their face that they involve cross-border transactions. It does not apply at all to checks. Convention Articles 1, Section 3, 2, Section 1, and 2, Section 2. Moreover, because it applies only if the bill or note specifically calls for application of the convention. Convention Article 1, there is little chance that the convention will apply accidentally to a transaction that the parties intended to be governed by this article. 3-104, negotiable instrument. A, except as provided in subsections C and D, negotiable instrument means an unconditional promise or order to pay a fixed amount of money with or without interest or other charges described in the promise or order if it, 1, is payable to bearer or to order at the time it is issued or first comes into possession of a holder. 2, is payable on demand or at a definite time. And 3, does not state any other undertaking or instruction by the person promising or ordering payment to do any act in addition. 1, an undertaking or power to give, maintain, or protect collateral to secure payment. II, an authorization or power to the holder to confess judgment or realize on or depose of collateral, or III, a waiver of the benefit of any law intended for the advantage or protection of an obligor. B, instrument means a negotiable instrument. C, an order that meets all of the requirements of subsection A except paragraph 1 and otherwise falls within the definition of a check in subsection F, is a negotiable instrument and a check. D, a promise or order other than a check is not an instrument if at the time it is issued or first comes into possession of a holder, it contains a conspicuous statement, however expressed, to the effect that the promise or order is not negotiable or is not an instrument governed by this article. E, an instrument is a note if it is a promise and is a draft if it is an order. If the instrument falls within the definition of both note and draft, a person entitled to enforce the instrument may treat it as either. F, check means I, a draft other than a documentary draft payable on demand and drawn on a bank, or II, a check cashier's check or teller's check. An instrument may be a check even though it is described on its face by another term, such as money order. G, cashier's check. I, means a draft with respect to which the drawer and drawee are the same bank or branches of the same bank. H, teller's check, means a draft drawn by a bank, on another bank or through a bank. I, traveler's check, means an instrument that I, is payable on demand, II, is drawn on or payable at or through a bank, III, is a designated by the term traveler's check or by a substantially similar term, and IV, requires as a condition to payment a counter signature by a person whose specimen signature appears on the instrument. J, acknowledgement by a bank that a sum of money has been received by the bank and a promise by the bank to repay the sum of money. A certificate of deposit is a note of the bank. Instruments are divided into two general categories, drafts and notes. A draft is an instrument that is an order. A note is an instrument that is a promise. Section 3-104C, that's section E. The term bill of exchange is not used in Article 3. It is generally understood to be a synonym for the term draft. Subsections F through J define particular instruments that fall within the categories of draft or note. The term draft, defined in subsection E, includes a check, which is defined in subsection F. Check includes a share draft drawn on a credit union payable through a bank because the definition of bank, section 4-105, includes credit unions. However, a draft drawn on an insurance company payable through a bank is not a check because it is not drawn on a bank. Money orders are sold both by banks and non-banks. They vary in form, and their form determines how they are treated in Article 3. The most common form of money order sold by banks is that of ordinary check drawn by the purchaser, except that the amount is machine impressed. That kind of money order is a check under Article 3 and is subject to a stop order by the purchaser drawer, as in the case of ordinary checks. The seller bank is the drawee and has no obligation to a holder to pay the money order. If a money order falls within the definition of a teller's check, the rules applicable to teller's checks apply. Postal money orders are subject to federal law. Teller's check is separately defined in subsection H. A teller's check is always drawn by a bank and is usually drawn on another bank. In some cases, a teller's check is drawn on a non-blank but is made payable at or through a bank. Article 3 treats both types of teller's checks identically, and both are included in the definition of a check. A cashier's check, defined in subsection G, is also included in the definition of check. Traveler's checks are issued both by banks and non-banks and may be in the form of a note or draft. Subsection I states the essential characteristics of a traveler's check. The requirement that the instrument be drawn on or payable at or through a bank may be satisfied without words on the instrument that identify a bank as drawee or paying agent, as so long as the instrument bears an appropriate routing number that identifies a bank as paying agent. The definitions in Regulation CC Section 229.2 of the terms checks, cashier's check, teller's check, and traveler's check are different from the definitions of those in Article 3. Certificates of deposit are treated in former Article 3 as a separate type of instrument. In revised Article 3, Section 3-104J treats them as notes. There are some differences between requirements of Article 3 and the requirements included in Article 3 of the Convention of International Bills of Exchange and International Promissory Notes. Most obviously, the Convention does not include the limitation on extraneous undertakings set forth in Section 3-104A3 and does not permit documents payable to bearer that would be permissible under Section 3-104A1 and Section 3-109. See Convention Article 3. In most respects, however, the requirements of 3-104 and Article 3 of the Convention are quite similar. Banker's acceptance. Title 12, Section 372A. Institutions, drafts, and bills of exchange. Types: any member bank and any federal or state branch or agency of a foreign bank subject to reserve requirements under Section 3105 of this title hereinafter in this section referred to as institutions, may accept drafts or bills of exchange drawn upon it having not more than 6 months sight to run, exclusive of days of grace. I, which grows out of transactions involving the importation or exportation of goods. II, which grown out of transactions involving the domestic shipment of goods, or III, which are secured at the time of acceptance by a warehouse receipt or other document conveying or securing title covering readily marketable staples. B. Ratio limit of bills to unimpaired capital stock and surplus except as provided in subsection C of this section. No institution shall accept such bills or be obligated for a participation shall in such bills in an amount equal at any time in the aggregate to more than 150% of its paid up and unimpaired capital stock and surplus, or in the case of a United States branch or agency of a foreign bank, its dollar equivalent as determined by the board under subsection H of this section. C. Authorization for special ratio limit. Foreign banks, the board, under such conditions as it may prescribe, may authorize by regulation or order any institution to accept such bills in an amount not exceeding any time in the aggregate 2% of its paid up and unimpaired capital stock and surplus, or in the case of a United States branch or agency of a foreign bank, its dollar equivalent as determined by the board under subsection H of this section. I'm being shot in the right inner eye with a directed energy laser. And my eye is really irritated. It's okay. I'm gonna sink the fucking battleship. D. Ratio limit for domestic transactions, notwithstanding subsections B and C of this section, with respect to any institution. The aggregate acceptances, including obligations for a participation share in such acceptances, growing out of domestic transactions, shall not exceed 50% of the aggregate of all acceptances, including obligations for a participation shall in such acceptances authorize for such institution under this section. E. Ratio limit for single entity. Foreign banks security, no institution shall accept such bills or be obligated for a participation. Why can I say that? Participation share in such bills, whether in a foreign or domestic transaction, for any one person, partnership, corporation, association, or other entity in an amount equal at any time in the aggregate to more than 10% of its paid up and unimpaired capital stock and surplus, or in the case of a United States branch or agency of a foreign bank, its dollar equivalent as determined by the board under subsection H of this section, unless the institution is secured either by attached documents or by some other actual security growing out of the same transaction as the acceptance. F. Exception for participation agreements. With respect to an institution which issues an acceptance, the limitations contained in this section shall not apply to that portion of an acceptance which is issued by such institution and which is covered by a participation agreement sold to another institution. Q. Definitions by board. In order to carry out the purposes of this section, the board may define any of the terms used in this section, and with respect to institutions which do not have capital or capital stock, the board shall define an equivalent measure to which the limitations contained in this section shall apply. H. Dollar equivalent of foreign bank, paid up, capital stock, and surplus. Any limitation or restriction in this section based on paid up and unimpaired capital stock and surplus of an institution shall be deemed to refer with respect to a United States branch or agency of a foreign bank to the dollar equivalent of the paid up capital stock and surplus of the foreign bank as determined by the board. And if the foreign bank has more than United States branch or agency, the business transacted by all such branches and agencies shall be aggregated in determining compliance with a limitation or restriction. Bills of exchange have not been discontinued or done away with. They are called drafts. In a recent conversation with Walker Todd, ex-chief and legal counsel for the Federal Reserve, he divulged to me that reserve requirements were waived under Title 12, Section 3105. Prior to this, on time deposit accounts, these are accounts where the funds cannot be withdrawn for a fixed period of time and then only after notice, were given an exemption as a reserve requirement, and this exemption was used or tendered through a bill of exchange and was one of the instruments for loaning money. Guess what replaced the reserve requirements under time deposits? Your exemption as the principal on the private side. All monetized debt has to have a principal from which capital and interest circulates. This capital and interest is called accruals under GAAP. This is where the accrual method of accounting is derived from. Under this method of accounting, the debits and credits have to be in balance. This is accomplished through reverse bookkeeping entries or matching principles. This can only be accomplished in the courtroom when you do an acceptance for honor of the charges or charging instruments, indictment, complaint, information, or summons. Then the debt, liability, or deficit, which is represented by the charging instrument, can be zeroed out by transferring the credit or liabilities over to the debt or asset side of the accounting ledger by the clerk of the court. That's right, bunkies. The clerk of the court is a public accountant, and the docket sheet is an accounting ledger for intermediate accounting entries and practices. They have to pass the credits or liabilities through your account to effectuate post-settlement and closure of your account through reverse bookkeeping entries. Why? Because the public side is where the bankruptcy or insolvency is through contract and agreement under the Hague Conventions and the public policy of HJR 192 codified at Title 31, Section 5118 2D. The Social Security number on the front of your Social Security card is assigned to the debtor or straw man. The red number on the back of the card is your exempt, priority, prepaid account number and is assigned to one of the 12 Federal Reserve banks, designated by the letter in the front of the number. There are 12 letters and 8 numbers after the letter. These letters designate which Federal Reserve district or bank is handling your account. The 8-digit number is your account number. All chargebacks should be to this bank and not the Secretary of the Treasury, who in reality is the Secretary of the Treasury of Puerto Rico. The office of the Secretary of the Treasury of the United States was done away with in 1926. I have the legislative documentation of this. The International Monetary Fund has replaced the office of the Secretary of the Treasury of the United States, which was or is being chaired by Nicholas Brandy. The letters below designate which district or bank is handling your account as the fiduciary trustee in bankruptcy. The 8 numbers on the front of the Federal Reserve notes have 2 identical series of numbers and 2 letters. One is a prefix and the other is a suffix letter. located in the upper right and lower left sections of the note. If you study this in detail, you will find out that your red number on the back of the Social Security card corresponds to the serial numbers on the front of Federal Reserve notes. They both have 8 numbers or digits. I do not think that is a coincidence. A is Boston, B is New York, C is Philadelphia, D is Cleveland, E is Richmond, F is Atlanta, G is Chicago, H is St. Louis, I is Minneapolis, J is Kansas City, K is Dallas, and L is San Francisco. The whole problem, and nothing else, is that the public and national debt or deficit is not being redeemed on the public side through your exemption on the private side. This is the reason you have runaway inflation and wars in the public realms. The reason wars are fought is to kill and execute people to cancel the debt. You will find out that under Title 12, Section 1811 and Section 3104, Insurance of Deposits, every demand deposit account, including checking, savings, and credit card accounts, are insured under the FDIA, Federal Depository Insurance Act, through the FDIC, Federal Depository Insurance Corporation. Title 12, Section 1811A, when they execute the debtor to eliminate the debt, they also collect the insurance money. You are actually worth more dead, which is a debt, than alive. Why do you think the police are so quick to shoot people? This executes or eliminates both the debtor and the debt in one swift action or execution. This is all karmic and involves the laws of karma, which in physics involves the laws of cause and effect. This is also the occult or hidden meaning of the scriptures in regard to salvation and redemption. Let me write that down. That's like so important. Page 57. This is, oh my God, this is like gold. This is gold. Anybody who tries to run from the police is called an absconding debtor in Admiralty Maritime Law and may be shot or captured under the law of prize. Read the case of J. Monroe versus Joseph Almeida, 23 U.S. 473, 10 Wheat 473, 6 LED 473. This is one of the best cases I have ever read on the Admiralty and civil law and how it is being applied in the courts. Another excellent case, hang on a second, let me write that down. I need to contact that guy that was doing that case last night of the man who was shot here in Florida. I should send this to him, that section. J. Monroe versus Joseph Almeida. That's 23 USC 473. Another excellent case is Ramsey versus Allegre, U.S., MD, 25 U.S. 611, 12 Wheat 611, 6 LED 746, which says they must have your consent before they prosecute you. Another excellent case is Lindo versus Rodney, 2 Douglas 613. This is an extremely difficult case to find and research. This case is quoted in L.E. Cox v. Eden, Volume 99, English Reports, page 375, or at 2 Douglas 595. This case was decided the 7th day of February, 1781, by Lord Mansfield, possibly one of the greatest jurists of Admiralty who ever sat on the King's Bench. An action will not lie at common law for false imprisonment, where the imprisonment was merely in consequence of taking a ship as prize, although the ship has been acquitted. Lord Mansfield said that the action a new attempt, which, if it succeeded, would destroy the British Navy. If an action at law should lie by the owners, and every man on board a ship taken as prize, against the captor and every man on board his ship, no man would dare to take a ship. Page 595 or page 375 of English Reports. Quote, besides, the argument of policy, such as it is, does not apply in the present instance, because this defendant is captain of a letter of marque, who acts voluntarily for his own private profit and that of his owners, not as officers in the Navy under public compulsive authority. As to the other ground, that if there is a remedy, it must not be sought in a court of common law, but in the court of admiralty. The inconvenience will be just as great because the judicature for the same multiplicity of suits may arise there. The current Suits and Admiralty Act, passed in 1920, gives injured parties the right to sue the government in Admiralty. Title 46, Appendix Section 741-752, and the Public Vessels Act, enacted in 1925, to allow claims against the United States for damages caused by one of its vessels. Title 46, USCA, Appendix Section 781 through 790. I have found that most people do not know the difference between federal common law and English common law. All the English common law was grounded in substance and ownership of property through allodial title. The people did not have title to anything under the current system. The only rights they have are remedies as defined in 1-201 of the UCC Federal Common Law, is that decisional body of law, rules of decision, commercial, that came out of the Eyre v. Tompkins 304 U.S. 64-58 Supreme Court 817 1938 decision. I have read over 250 law review articles, and only one tells you what happened in 1938. The name of the journal is the American Bar Association Journal, Volume 24, January 1938. The name of the article is What Happened to Federal Jurisprudence, by Albert Schwepp of the Seattle Bar Association. The best article, bar none, is The Supreme Court and the Post-Erie Federal Common Law by John P. Lunnington, LLB 31, L edition, 2D, page 1006. What happened in 1938 is that they changed the rules of decisions under Section 34 of the Judiciary Act of 1789 from the English common law to the federal common law. Prior to this, English common law was called the General Federal Common Law. In Interpol Limited v. Char Yai Marine, Panama, SA 890F 2D, page 1453, 1989, it states that in maritime commercial transactions, the Uniform Commercial Code is taken as indicative of Federal Common Law of Admiralty. This says it all. Another excellent case is the Cartona 296 Federal Reporter, First Series, page 827. This case says you have to have an interest or a lien before you can intervene with a claim in admiralty under Rule 24 of the FRCP. In the United States, everything started with the Civil War and the Insurrection and Rebellion Acts of August 6, 1861 and July 17, 1862, which are still current law today under Title 50, Sections 212 and 213. We have been under a military provisional occupational government since 1861. This is why the United States has been divided into internal revenue districts under Title 26, Section 7621 by the President of the United States and is what the zip code designates. What Franklin Delano Roosevelt did in June of 1933 is he sold more gold contracts that the Treasury had gold. This created a marine peril or peril of the sea because of the run on the Treasury due to the foreign gold contracts. To avert the loss of gold due to the run on the Treasury, Roosevelt outlawed gold and gold contracts to avert the apparent peril or loss of gold in the Treasury. In admiralty, anytime cargo, which is gold, is sacrificed to avert the peril of the sinking or loss of the ship, everybody who is a passenger on the ship or vessel, the United States, has to pay for the loss or sacrifice through the doctrine of contribution. They had to